Lordship may be permitted to mention a matter praying for leave to file without certified copy.
Why? What is the urgency?
Urgency is that Lordship title should filed. Execution have filed. No copy have been served upon me. I have received copy of a summon when at the time of filing.
When have you applied for the certified copy?
I have
What is the date of the order?
Date of the order 16th June 2025.
File with the certified copy. Yes, call the list.
Item number 1, my lord, item number 1, yesterday I mentioned the matter for correction.
Yes.
My lord, the first paragraph, my lord, second last line, dispose of the miscellaneous case number 176 of 2020, which has been renumbered as, my lord, that is, my lord, not the case, my lord. 176 is a separate proceeding and 401, my lord, is a separate proceeding. 401 is the, my lord, miss case where, my lord, has passed the order for expeditious disposal, and 176 is, my lord, on which, my lord, stay is there by my lord itself.
See your prayer.
My lord, I am the respondent. I am not the petitioner.
Where is the petitioner?
So
Please serve him, because prayer is that.
my lord, that is why, my lord, on the last occasion, my lord, I indicated, my lord, this was filed prior
All right,
to
ask him. I'm keeping it on Monday.
Monday, my lord, I shall serve a notice,
Yes,
my lord.
ask him to come, because it was on, and the prayer portion is both to be disposed of. That's why it was.
Yes, but after that, my lord, pass a stay on this 176 proceeding, my lord. That order.
If stay order is there, it's there.
My lord, but my lord knows, my lord, how, my lord.
No, but I have only directed this case number 401 of 2018
Yes,
to be
but
disposed of.
this case
That was
renumbered.
the, oh, not renumbered is all right.
Yes, that is the only.
Ashwin.
And I'm only
In the first paragraph,
Bank, your lordship. Kindly transfer a short passover. My senior is on his way.
Passover. Yes, what is this matter about?
My lord, there was a DIT order challenging that DIT order. We came before your lordship, where lordship pleased to reduce down our quantum of pre-deposit amount,
Yes.
which we are liable to pay.
Yes.
My lord, now the thing is, in another matter related to PF, particular bank.
What do you want?
My lord, we want particular time because bank dropped.
Can one of 2025 has been filed by you?
Yes, my lord.
What is the prayer?
Prayer is, my lord, bank has freezed.
Extend the time to make the pre-deposit.
My lord, because our amount, my account is freezed. And
how much time you want?
Lordship,
My
you are
lord-
vehemently opposing that. Lordship, there are many submissions that needs to be made by my senior, and he's on his way.
How much time do you want?
My lord, 1 month and not.
Come at 12. Ask your senior to come. Come at 12. Yes, next.
Item number 3, I appear for the petitioner. Well, this is my affidavit of service.
Yes.
Before I start anything, my lord, I'd like to point out something. In the last order, my lord, kindly sees.
Yes.
It was recorded that the bailiff never went to the suit property, and there was no other, they could not find the petitioner. My lord, at that point in time, I did not have the bailiff report available to me. I have the bailiff report. May I just show to your lordship, my lord? This is with regard to the fact that I have filed my 7172 within 30 days of my date of appearance, since summons were never served upon me, my lord.
Yes, sir. What do you say?
They had appeared on 30th November 2022.
30th November 2022. Yes.
22. The suit was shifted to ex parte board on 5/4/2023.
No, when did they file the application under section 7.2? They appeared on 30th of November 2022, when 7.2 was filed.
7/2.
Yes. Because here 7.1 and 7.2 was rejected because it was filed beyond the stipulated time. They appeared on 30th of November when the 7.2 was filed.
তিন নম্বর এটা
সুধীর তিওয়ারি?
না
No, not this matter. I am not in this
We are
matter.
not in this matter.
this is the certified copy of the order sheet, my lord, showing I have filed within 30 days, my lord.
But the registered envelope returned with the envelope unclaimed, that's good service.
No, my lord, it did not.
That is good service, sir.
May I just, my lord? This is not unclaimed.
Yes.
No, my lord,
Does
I
the-
have the photocopies of the,
Where is the belief report?
I have the belief. My lord, kindly see, there is no witness attested to the belief report.
That's a different thing altogether.
No, no,
What is the service returns? When the opposite parties have received this copy of the civil division application,
My lord, that's my affidavit of service is there, my lord. Affidavit of service. There's a issue with regard to the website of the, I had to inquire from. It says item delivered.
when, what is the date?
My lord, may I just point out, my lord?
Yes, please show me the date.
পরের বছর ডেলিভারি নিচে ঠিক আছে
First of August,
1st of August. I posted on 31st of July,
31st of July.
my lord.
So I'm keeping it on Monday.
Very well, very well.
Monday রেখে দিন। Yes,
Under heading for orders, my lord. Under the heading for orders.
same heading.
I'm
Yes,
grateful.
next. Yes, call the next matter.
ঠিক আছে, number 4.
Oh, yes,
Petition number 4 petitioner. For sitting aside the expiry of the evidence, I filed an 151 application before the learned court below. The plaintiff witness has been concluded and closed and
you are the defendant.
and the defendant number 4.
Yes,
Now on that day, due to the my health issue of my learned senior, I filed an application for adjournment petition also by the
that was rejected.
that was
Cross-examination closed.
closed. I am praying for just I have not yet filed the written statement. I don't want to that. I want to cross-examine the
What
plaintiff
is the suit for?
suit for declaration of title and injunction. They are claiming
And
their
cancellation of deed.
they are claiming a title on the basis of the one deed. The deed is question. Veracity of the deed is there.
Mr. Ghosh, it's the PW3 which has been closed. PW1, PW2 already, you have not cross-examined PW1 and PW2?
No.
What will be done with cross-examining only one witness?
For expertise.
Anything left for you?
Yes, if give me I
What do you say?
My lord, they were declared ex parte on 5/4/2023. Till date, they have not filed any written. Now, even they did not move their application for adjournment, that is. And my client is 86 years old. Prior to that, they compelled my client to sign on a paper that the suit will be withdrawn. Later on, my client somehow managed and suit did not withdraw. They preferred a revisional application that was dismissed. And now they are taking this dilatory tactics. And the forged, my signature of my client was forged. The FSL report is there. It has been affirmed. So they have nothing to say.
Cross-examination 1 day, cross-examination PW3.
Fixed a date,
If
malad, on
that be so, kindly give a time frame so that the
Yes,
matter
yes,
may be.
1 day, Mr. Ghosh. Only 1 day cross-examination will be permitted. How much cost he will pay?
malad, upon the all plaintiff witnesses, the PW 1, 2, 3, malad,
Mr. Ghosh, no.
malad,
Order 9, Rule 7 permits you to proceed from that stage even without good cause being shown.
malad, from that,
So
from that-
because everything was rejected, prayer for adjournment, so he could not show good cause, I will allow you to proceed from that stage.
yes, malad, I am
Only PW3, nothing.
No,
Cannot be relegated
PSC
back to any other previous stage. That's not your application also. So only the prayer for adjournment on cross-examination of PW3 was rejected.
PW3 করুন না, তাতেই হবে।
And you have not filed any application under Order 9, Rule 7.
That's it.
So I will only permit PW3 to cross-examine. What is the next date fixed?
On 28/7 was the last date. তারপরে
What is the next date fixed?
কবে ডেট হয়েছে?
And how much cost? Be reasonable, Mr. Ghosh.
malad, kindly come,
5 figure. Don't take it
malad,
4 figure.
prior to come, prior to them, malad, please come to malad page 4.
If you open the brief, then
No, no,
it may.
malad, only malad, I appeared malad from December 5th, 2023.
Yes.
Malad, on that, malad, I appeared on that day.
Yes.
No,
So-
defendant appeared on 2022, the 30th/11.
Thereafter ex parte. It was proceeding ex parte. You did not apply for vacating the ex parte.
Malad, regarding cost, malad,
No, tell me, be reasonable, 5 figure, any quantum you quote. I will accept.
malad, kindly.
28th August is the next date.
Yes, malad, on that day, malad,
Yes, what do you say with regard to the cost?
করুন না কিছু। My lord, I'll leave it to your lordship.
You are leaving to the court, then it's difficult. When you are leaving to the court,
My client is 86 years old. He is suffering. So
PW3 কে করে কিচ্ছু হবে না। PW1 কে দরকার।
PW1 কবে close হয়েছে?
let it be 50,000
I will
cost
file
will
it.
given. 50,000.
50,000.
দেবে না তো, দেবে না।
You left it to the court, now you are
No,
saying 50,000.
I'm leaving it to your lordship.
50,000
আমি বলেই চুপ করে থাকছি। আমি বলি
Mr. Ghosh, you filed any application before the court for recalling? No.
Malad, recalling 151, malad, the
Where is that? Where is that application?
Can accept you.
By which order it was closed? Concluded 2nd of July.
last malad, my application,
No, 2nd of July 2025. PW1 was examined in full and concluded. When PW3 was examined.
malad, kindly come to page 14, my application,
Page?
page 14.
অর্ডার গুলো বার কর না।
My application of 151, malad, and a prior page 17, malad, by that order, malad, when I prefer vacating, malad, the expiry.
Allowing the defendant number 4 to appear as spread for him in the petition already for vacating the ex parte by setting aside the very good, Mr. Ghosh, you have stated the legal position. You have clarified the legal position in paragraph 6 of your application itself. You have very well clarified what's the position, how to be relegated back, when not to be relegated back. It's nice to see that in the application this legal position has been clarified.
This is the order of 5/4/2023.
Yes. Paragraph So this was filed when shifting back. This was rejected.
Yes.
This was rejected by which order?
28th March.
28th March.
This is
Oh, that order you are challenging?
Yes.
28th of March. No, 28th of March. Only it was filed. None moved.
मतलब 28th order being number 19, मतलब 28th March, मतलब now order is there. Order being number 19, my petition under 151
151 was rejected
rejected.
because you did not move that. Then it is to be restored because no decision on 151 was passed. I'm restoring that. Ashun, this application, I'm not allowing him to cross-examine. I'm only restoring. On that date, this 151 will be hard. This application under section 150.
My client is 86 years old. If
Maybe,
he
but
dies,
2022 suits, sir. All suits nowadays, after issuance of summons, an application for expeditious hearing. First day, ad interim injunction, date fixed, preponed, allowed, expeditious hearing.
but here I have
Preponing allowed on that date, even then, expeditious hearing. These are the types of civil expeditious hearing applications which are coming. Yes, next.
Item number 5.
My lord, I appear for the petitioner.
Yes.
My application for extension of interim order expired on 31st of July. I have filed the application prior to that. I have served the copies, my lord.
I submit one thing, my lord. My lord, the impugned order herein, my lord, is acted upon, my lord, before filing this application, my lord.
Acted upon. What is the impugned order?
The impugned order is filed, my lord, to inspection the suit property. My lord, the learned court,
Madam, if the order is set aside, everything goes.
my lord, I am here, my lord, opposite party. They are also, my lord, I am opposite party, my lord. They are suit, my lord.
Yes,
My
they
lord,
want their suit to be stayed. What can be done?
dispute between the parties, my lord, the disputed question of facts, my lord.
That I
If
will
they want to proceed with the suit, my lord, my lord, they are absolutely their discussion, my lord. But my lord, the dispute between the parties will be there, my lord, and that is why, my lord, I am praying before your lordship.
Local inspection was allowed
Locally,
at your instance. At your instance.
they
Show
have
me the points of local inspection. Show me the points. What is the suit for?
sued for declaration and permanent injunction.
Yes.
Thereafter, my lord, their application for local inspection under Order 39, Rule 7, instead of Order 26, Rule 9.
My report has
And
been
my lord,
filed. My lord, page 17 of GA, my lord, can 1. This is the report, page 17, page 18.
page 44, kindly come once. Page 44.
Give me a minute. For local inspection,
Page 44, the operative portion, points of local inspection.
44.
44. My application, not their application for vacating. To inspect the suit property and to report whether on the eastern portion of the suit plot there are residential structures of defendant number 1 and his family.
Yes, madam. How these points will help in the adjudication of
My
the suit?
lord, my lord,
Yes.
already report has been filed.
Maybe, madam, maybe the report has been filed. Satisfy me how this local inspection can help in the adjudication of the suit. Suit is for declaration of title and permanent injunction.
My lord,
Please satisfy me
my
on
lord,
that.
the report is saying, my lord, the physical.
Madam, I will not go to the report. I will not look into the report. I am on the order allowing an application for local inspection. Maybe report has been filed. Maybe the commissioner has undertaken. I am asking you how that will help in adjudication of a suit for declaration of title and permanent injunction.
My lord, the learned.
What for?
My lord,
Merely collection of evidence.
my lord.
Yes.
Then, my lord, let them proceed the suit, my lord.
Yes, yes.
Dispute will be
But
decided.
this
my
has to be set aside. This application under Article 227 of the Yes, next.
Petition number 6.
ক্যানটা তো প্রথমেই ডিসপোজ অফ করে দিন। আরেকটা ক্যান আছে, ডিসপোজ অফ করে দিন। আর কি আছে? Disposed of all pending applications stands disposed of. Yes, next.
For extension of interim. This Madam Mr. Soitali Bhattacharya is appearing for the opposite party. She has undergone some operation, my lord. She has not come to court, my lord.
All right.
Can be taken up Monday week, my lord. In the meantime,
When the interim order till how?
this
Till the end of August. Till the end of August it is there.
it will be cutting too fine, my lord. It
Why?
will be cutting. Well, we have to mention if I miss one day, it takes me 14 days.
Is it so? Extension of interim order, it takes 14 days for
No, my lord,
business day.
mentioning is allowed only on Wednesdays.
Yes.
That is the my lord. And exigencies of my old age, my lord.
Ashun. The yes.
Opposite party number 2. Opposite party number. OP1. No, that I'm on behalf of the opposite party number 2, my lord.
Mr. Dushant Madura is appearing online.
Where is
My lord,
the?
I'm there for the opposite party number 1.
Yes.
My lord, both the cans, my lord, it's a legal aid matter so far as the OP1 is concerned. I'm in some difficulty today, my lord. I'm in Delhi and I did not expect this matter to be listed today. And neither of the cans have been served on my client, my lord.
Doctor, why the applications have not been served? But they are saying they have not received the applications. What are the applications for? Why did you not take steps for extension within time, Mr. Doctor? No, that I appreciate, but why did you not take steps for extension? Yes. When did it expire?
My lord, possibly end of April.
First week of May.
First week.
Yes, Mr. Bhoshi, you are appearing for?
Both lords, my senior lords.
Mr. Gupta, you are for opposite party number 2.
Opposite party number 2, my
Mr.
lord.
Medora is for opposite party number 1.
1, my lord, yes.
What is the dispute?
My lord, this is a matter, my lord, delay of condonation of delay, my lord, in respect of an appeal filed in a consumer forum matter.
Delay in filing, my lord, the appeal before national forum. And
Yes.
national forum, my lord, on the ground of delay, my lord, my application was rejected.
What is the period of delay?
The 227.
And you have challenged under Article 227 for 227 days delay.
Then, my lord, we moved it from our Delhi High Court. And, my lord, there is.
The High Court do not have jurisdiction. It's well settled because jurisdictional court means where the first commission is located. That's well settled.
First in order for a wrong jurisdiction. With some protection, my lord, not to coercive action. And, my lord, then, my lord.
Who are you?
Well, I am the, my lord, medical college and hospital, my lord. Calcutta
What is the deficiency of service on your part? What have you done?
This is the allegation, my lord, that I have committed, my lord, the doctor can be considered the suspect. The patient was, my lord, admitted in lawsuit file. Can you consider, say, my lord?
Yes, Mr. Medora, are you seriously opposing the condonation prayer?
Yes, my lord. It's a legal aid matter also, my lord, so I will be failing in my...
Legal aid matter is a different thing altogether, but এটা কি সব আটকে গেছে কেন? বাবা What is the, why are you seriously opposing the condonation? Let it be harder.
The 279 days delay, my lord. No proper explanation has been given for the same.
The length is not material, sufficiency of the cause is to be looked into. That's the settled law. So,
I know.
so if this is the dispute, deficiency of service on the part of an hospital, can it not be considered on merits? Let it be decided on merits.
I bow down to your lordship. I normally do not like opposing such matters.
All right. So, when will you be available physically?
My lord, Monday, Tuesday, any day next week, my lord.
Any day next week.
Any day next week, my lord.
Doctor, it has expired already. I'm keeping it on Monday.
Grateful, my lord.
File application. Before expiry, I file application
For the extension, the interim order.
for extension, my lord. And my lord,
Why they are executing?
executive my trial court is not a thought. I paid for time. Earlier, my lord, when the motion was admitted, the Honorable Justice, my lord, Rajabhushan Chaudhary, my lord, directed me to make an application and file application for adjournment. 10,000 cost has been imposed. Then, my lord, I filed an application for.
My lord, execution case is fixed on 18th, my lord. Execution case.
18th of?
18th of this month, my lord.
But it has to be hard because Mr. Medora is.
You lost it extended for.
Then, Mr. Medora, I am extending the interim order. I am fixing it on a day.
Very well, my lord. Or I can come and do it on Monday and your lordship can decide the matter once and for all. I leave it to you, my lord.
Yes, for the present, I am extending this.
My lord, instead of Monday, your lordship can fix it on Wednesday. My lord, Monday, I have some. হ্যাঁ না মানডে বলছেন তো উনি আমি সেটা
Ashun. This is an application for extension of interim. Can
In the month of August, my lordship fix any date.
August is full.
Full. Then let September, first week September.
First week of September.
September up to 11th full.
Up to 11th.
11th of September.
Then let's say where are we going, lordship? If the lordship will give me adjust lordship any day lordship before.
All days.
The 12th lordship
is from 3:30, 4 p.m. It's
then
all days are
12 September lordship. If the 11th is fixed, then 12 lordship.
They are wanting so Monday you lordship can fix it on Monday.
Can'টাতেই order করে দিন.
Yes, my lord.
Mr. Dotto, which is the effective can for extension? Can 1 or can 2?
My lord, can 2.
What is can 1?
Can 1, my lord, for fresh interim order that was filed by my client.
That is pending or disposed of?
No, that is pending also.
Why?
My lord, that may be literally that application has been disposed of by passing the fresh interim order.
Can 2 তে করে দিন. This is an application for extension of interim order. First up, Mr. Dotto, learned advocate, appearing for the petitioner submits that the application was filed prior to expiry of the interim order, but for reasons beyond the control of the petitioner, the interim order could not be extended prior to its expiry. First up, heard the learned advocate for the opposite parties on such submission. First up, considering the fact that the application was filed prior to the expiry of the interim order, and after going through the averments made in the application, this court is inclined to pass a fresh interim order. There shall be an order of stay of.
In the earlier order, I enclosed my lord, you lordship fine. My lord, EA 4 of 2023. My application,
There shall be an order of stay of all further proceedings in execution case number EA/4/2023 pending before the West Bengal State Consumer Dispute Redressal Commission till the end of the month of November 2025 or until further orders, whichever is earlier. List this matter. সেপ্টেম্বরে দেখুন তো 11 তারিখের পরে কথা আছে।
কোর্ট সবসময় ফুল লিভ থাকে। September 15 lots.
Lord, your lordship, kindly.
Eighth of August,
My lord,
Thursday.
my lord.
List this matter on August 28, 2025 at 4:15 p.m.
If the lordship 3:30 is there, then lordship.
Mr. Voici, 4:15 in presence of all the
2
parties.
PM, lordship. 2 PM, your lordship, kindly.
Let me see. If it is 4:15, then mention.
The 2 PM, what is that, lordship? My lord,
It will be
2
a
PM.
contested hearing.
2 PM fix the lordship. 2 PM fix the lordship.
Why? What is the difficulty in 4:15?
Absolutely.
If it is 3:30, I will take it up at 3:15. Please mention it on that
Okay,
day.
Grateful, my lord.
4:15 with an understanding on that date, 4:15 or 3:15.
Oh, lordship.
Concluded on that day.
When the 3:30, then I mention. the
আচ্ছা দুটোই ক্যান ডিসপোজড অফ করে দেবেন ক্যান 2টা তো হয়ে গেল ডিসপোজড অফ passed in can 2 of 2025 nothing remains লিখে নিন in view of order passed in can 2 of 2025 can 1 এ আলাদা করে nothing remains to be decided in can 1 of 2025 accordingly this stands disposed of. Yes, next.
Item number 8. Item number 8, my lord.
আচ্ছা এফিডেভিট সার্ভিসটা কার্ড দেখুন
The opposite party.
For an extension of interim order,
I am
it
opposing
is
the,
filed within time.
I am
Initially,
opposing the interim.
I
order.
received-
extension of interim order. Yes, you are for the petitioner.
Yes, yes.
Yes,
Initially, it was passed on 7/10/2024.
yes,
Subsequently,
so I am extending it. The matter is appearing in the list.
Yes, my lord.
yes,
in the last
I can't
occasion,
fix
my
the
lord
date.
speak-
but it will take some
Matter is appearing in the list when under which what heading?
contested appeals.
For contested.
Contested application.
Contested.
My lord, the problem is that, my lord, the execution cannot be proceeded with. My lord, that
Can 3 of 2025. This is an can 3 disposed of. Yes,
So if my lord will kindly fix a time for the hearing, because my lord, the matter is not taken up. That is why. If my lord will kindly fix a date for hearing of the,
contested application, sir. It's difficult now.
I am grateful. my lord.
Item
Yes.
number 9, my lord, I am applying for the petitioner. I am filing my affidavit of service, my lord.
Caveat is there.
my lord.
Caveat is there.
No, my lord directed.
For directed service.
Yes, but difficulty is this, my lord, due to some difficulties, my lord, the track report is not available, but I have got an SMS from the postal department that the article has been delivered on 31st July 2025.
31st July 2025, last day.
I tell your lordship, my lord, it was served earlier. My lord, I was late in service. My lord, due to
All right, so I'm extending, but you communicate this order.
definitely.
Evidence service filed in court today is taken on record. First up, the learned
disposal, my lord. My lord, in this case, my lord,
of what?
my lord, of a title execution case as well as the miscellaneous case, say praying for setting aside of the ex parte order by the tenant, my lord.
That has to
My
be
lord,
disposed of
they
first.
have, my lord, it is my lord, the oldest petitioner is 82 years old and the
The
youngest one is,
miscellaneous case has to be disposed of first.
my lord, and my lord, the court is vacant, my lord, kindly on the charge.
Charge court cannot dispose of the entire.
My lord, 2G, my lord, under section 2G, it has.
Maybe under whatever provision, but charge court cannot dispose of this case.
My lord,
It's very
since
difficult
it
because
is
the charge
pending.
court.
My lord, it is 20 almost a year back, the last date was there. My lord, 23rd
This
August, the
application
last
under Article
hearing was.
27 of the Constitution of
I appear for the petitioner. Lordship, I am withdrawing this application. This is an appealable order.
the what is the nature of the order?
340 rejected.
Oh,
This is an appealable order.
the learned advocate appearing for the petitioner submits that through yes,
My lord, almost identical, my lord.
almost identical.
Almost
This is also
identical.
Order 9 Rule 13.
Order 9 Rule 13. My lord, two suits, my lord. In earlier suits, they have appeared. In this matter, they did not appear at all.
All right. They can even do same order. আগেরটার মধ্যে here also the same court so regular
Same court, my lord.
same order আগেরটা যেটা
My lord,
same as in item number 10 শুধু suit number গুলো দেখে নেবেন ওগুলো কিন্তু চেঞ্জ হবে yes call the next matter
my lord, liberty to prepone, my lord. Liberty to prepone if the learned court joins, my lord.
December if you apply it cannot be preponed because 1 month is holiday
only effectively 2 months, my lord.
এটাও তাই একই থাকে।
Effectively 2 months only left.
That is well. Yes, call the next matter.
For the petitioner, my lord, in this matter laid by Mr. Roy, my lord. The challenge is
Yes.
section 36 application by Special Marriage Act, my lord. Petitioner is a husband therein. Lord, petitioner is he is maintaining his father's ailment expenses and mother's ailment expenses, my lord. So this is not possible for him to pay the said amount, my lord.
Don't pay.
Kindly be
Don't
set
pay.
aside the said amount, my lord.
Yes, what is your income?
My income is 65,000, but for my mother's
What is the
ailment,
document which you have produced?
document has
65,000?
There is no direction for
Affidavit of assets and liabilities happen. What is your income, Mr. Rai?
45,000 according to me.
Your income is 45,000. What is the document in support of your
Placed in your objection, you are placed in view of the কি
full file?
ভুল ফাইল চলে গেছে তাই জন্য খুঁজে বেড়াচ্ছে আচ্ছা এটা দেখেও গাল ইয়ে করছে well before that one whether Rajneesh versus Neha has been complied with or not. Rajneesh versus Neha not been complied with.
After all, Mr. Rai, you will be paying to your wife and son.
Yes,
Or
I am
daughter.
ready to pay.
Son or daughter.
Son, I am ready. Whatever may be the amount, your lordship. Wife is also a working lady. Wife is also a working lady.
What is her income?
According to us, 15,000 rupees.
15.
15, 1-5.
1-5. From how where she is employed?
Initially, my lord, is a brainware. After that, my lord, she is now.
15,000, Mr. Rai.
I could understand anything has been taken into consideration.
What's the alimony granted?
15,000.
So,
if the 15,000 is income, 15,000 alimony granted. My
no, son is also there.
yes, 15,000.
So for
both 15,000.
So 30,000, Mr. For two persons. The you have to maintain only yourself.
No, I have to take a loan from my father. That is there. I have to obtain loan from the bank for my father. Those documents are there. We have intended to produce those documents. And every month I have to pay rupees 20,000 on account of EMI.
For
repair
purchasing a palace. For purchasing a palace.
No. Those documents, if your lordship, if that be so, my lord, I can produce all the. I have in my objection, my lord, can return to my objection.
Any proceedings under the criminal procedure?
Yes, they have initiated 125, but not 498 and other things.
No. With regard to maintenance.
125 process has been initiated.
The order passed.
No order yet been passed.
Then, Mr. Rai, you comply with that. I'm directing you to serve.
As a Russian.
Because this
no, for the son, my lord, I am not disputing. I'll comply with the direction.
So, son, for that I am not interfering with. For the wife, I am directing you to serve. So, I please, with regard to the son.
On the very beginning, my lord, so the son is concerned, my lord.
I got your submission.
You know, late the order of the court, my lord. Sometimes, my lord, we had a talk with our client in some manner, my lord. It is a privilege to the court and the bar and the bench.
No. This Yes.
So this will create another problem because the my lord knows better than us. So for what is
No, that is right. But once I record that that has not been complied with,
yes.
affirming one part may be a problem because it can be also, they may come and challenge. That's the only thing.
But
Please give me the citation.
yes, this was the statement.
Yes, call the next matter.
The petitioner, my lord, there is a caveat, my lord. Kindly make it not today, my lord, Monday, my lord.
What is the impugned order?
The impugned order is that page, my lord.
What is the nature of the impugned order?
My lord, we are the my lord, plaintiff petitioner, my lord. We have filed one title suit for declaration of my lord title and my lord permanent injunction and recovery of possession, my lord. In that suit, we have my lord obtained an interim order of my lord status quo, my lord. They have violated the interim order against
What are the rule 2A?
Yes, my lord. We have against that they have preferred an appeal for the senior division. So that order goes against me, my against that order I have come.
The learned advocate appealing for the petitioner submits that call the next matter.
Green Lordship, my application, Lordship.
Yes.
Lordship, expeditious disposal
Of what?
of the title suit, Lordship, for declaration of title.
What is the stage of the suit?
Argument, Lordship. It is at the stage of argument, Lordship. Petitioner is the plaintiff. 2014 suit, renumbered as TS 65 of 2016, Lordship.
It's for argument.
Argument, Lordship. Argument.
Then why have you filed this application, madam? It's at the argument stage.
No, several dates has been fixed, Lordship. Several dates, Lordship. And previously, Lordship, the defendants, Lordship, they preferred an application for amendment. Similar, Lordship, title suit is
That is also argument.
argument stage, Lordship. The defendants, Lordship, they preferred an application for amendment under Order 6, Rule 17.
What happened to that?
Thereafter, Lordship, that was allowed for payment of.
Now it's argument.
That was done, Lordship.
Now it's argument.
Argument, Lordship.
Same order. ठीक है बस same order माने suit
Title
number
suit number is different.
Yes, next.
Next is also the same, Lordship.
That is also argument.
Herein, petitioner is the defendant, Lordship. Argument, Lordship, at the stage of argument.
It is the defendant.
Defendant.
17 is defendant.
Defendant, Lordship.
15, 16 both plaintiff.
Plaintiff.
It a defendant at the instance of the defendant. Yes, next. Call the next matter.
Number 18.
Yes.
Your Lordship, I am praying for not today. My senior is engaged in court number 32. I'm not acquainted with the case. My senior just instructed.
Ask him to come at 12. Pass over. Yes, next.
Item number 19.
None appears for the petition at the time.
My lord,
Yes,
this is my application.
yes.
It has a checkered history. I'm not going into originally the application was under section 34 in respect of an award which was passed on 22/6/2007. Thereafter, the section 34 was dismissed on 4th of April 2023. After
Section
the
34 dismissed
on the grounds section 14 not moved. Thereafter, the case has been revived. If my lord would come to order number 42, it's something would.
Order number 42. Yes.
Petitioner files a petition under section 151 CPC, copy not served. Petition, let it be kept with record. 2/5/7/25. My lord, this order is dated 24/4/23. Has my lord got it?
Yes. Now, what happened thereafter?
My lord, on the next day, on 5/7/23, when I appear,
yes,
day is fixed for hearing of 151 CPC, written objection, if any, records was misplaced. My lord knows what happens. I don't have to.
So 5th of July 2025, what happened?
Today is fixed for hearing under 151, written objection, if any, record was misplaced.
So record has not been traced out till now.
No, records were available for 2 years. What transpired for 2 years, no one knows. These
18th of August, it has been fixed for hearing.
18th of August, it has been fixed.
I'm directing that to be heard on that date.
My lord, during this entire period, no such averment was ever mentioned in the case status. A section 34, my lord knows is that review recalling 151, there is no such power to the
I
court
appreciate
available.
that, but from here I cannot set aside that. I'm directing on 18th to be taken up and to dispose of that 151 application. This application under Article 220.
it's been going on for now
That
20
is
years.
recorded for 2 years it was kept.
My lord, the award is 2007 and we are now in 25.
Arbitral award যেখানে বলেছি না pass sometimes. Yes, call the next matter.
Grateful, man.
Yes.
And the respondent, my lord, petitioner.
Respondent in the title appeal.
Title appeal. My lord, predecessor in interest of the opposite party, my lord, file a suit against my predecessor along with others, suit for a declaration that this RS record of rights is erroneous. That suit dismissed against that appeal paper. One of the now respondent number 4 in the appeal on the expired 2016. Well, they filed an application.
You are respondent number 4.
I am the years of the respondent number.
Yes.
Now, well, the 2019, well, filed an application for substitution. There is no prayer for the setting aside abatement, and that was not registered as miscase also. The learned court below by impugned order the recorded that this is within time.
Where is the application? It is within time.
Well, kindly see the last
From the date of knowledge. The court proceeded from the date of knowledge.
Yes.
No, it was filed in 2019.
2019 expired in the 2016.
Show me the application.
Well, application at page 36.
Did you give death intimation to the learned judge of the appellate court? Order 22, Rule 10, capital A. Did you comply with that, Mr. Ghosh?
But only that is there.
Then how do they come to know?
But the kindly see the that was not registered as miscase also. That is or order 22 rule 9 setting aside a miscase.
Where is the latest decision? Following 2003 volume 10 Supreme Court cases delivered by Justice Dotto. You have brought Mr. Ghosh. Following 2003, that's the parent judgment that was followed. This application under Article 227 of the Constitution of India is I will direct expeditious hearing.
On the next date fixed.
What is the next date fixed? Within a week, I am directing you to appear. After this order is passed, after
14th of this month is
14th of August, after this order is passed, Mr. Where are the references? Reference বলেছি কি নাকি well settled বলে কেটে দিয়েছে? Yes, next ছেড়ে দিন। Yes.
In item number 22, I am for the petition, my lord.
Yes,
My lord,
sir.
there might be some embarrassment in taking up this matter, my lord. My lord, kindly seize page number 17.
Page number
17, my lord. Your lordship has appeared for one of the parties in this matter, my lord.
Since I'm not inclined to take up this matter on Yes.
My lord, this is an expeditious disposal.
Of what?
My lord, the title shoot, my lord.
What
Initially,
is the stage of the suit?
my lord, the stage of the shoot, the opposite part, my lord, opposite party here in the defendant and lower court tendered their evidence in the 2012 cross-examination compared 2015 and 2015 the plaintiff tendered their evidences in regard to the 7-2. Now, my lord, in 2020 the plaintiff
70 is pending.
my lord,
70
72 is pending,
This
my lord.
application under Article 227 of
Yes, also for expeditious hearing, 2019 suit for partition. Lord, the injunction application of mine, my application for local 151 for police help, as well as Lord, another application for injunction in respect of recovery of possession of something that was made complete. In respect of the defendant side, one application for local inspection and one application under section 151 that is also made complete.
What is the next date fixed for hearing of those applications?
Not all the application, not both,
Yes, all the applications.
Yes.
24th of September.
24th September 2025.
This application under Article
Item number 2, Parotai.
Yes, for the list.
Item number 2. Yes, ma'am.
My lord,
Yes.
my lord, as per direction of your lordship, we are directed to pay 25% of pre-deposit. My lord, kindly comes to page number 12 of my application.
Yes, how much time you want?
My lord, subject to their conduct, my lord, because my lord,
I'm asking you, you have paid for extension of time. I'm asking you how much time you want.
my lord, 1 or 2 months. 1 or 2.
My lord,
One or two
already
months
may,
is.
my lord, may just hear me for
My lord,
one
give-
moment, my lord. Otherwise, I would not have stand in the way for extension. I never stand in the way. Initially, my lord passed the order, granted them 4 weeks time. That is way back in May. Today we are in August. Till now, they have not been able to deposit the money. Now they are taking a plea that one of my account has been defreezed, and for such just a second, sir, and for such reason we are unable to deposit the money. I have complete objection to it because this is a complete incorrect fact, and they are playing around with it.
I will not record anything on this prayer. I will give them, extend them time as a last.
My lord, another be peremptory because already they have got 3-4 months time.
Peremptory, I will, they have to deposit by the end of this month.
I'm so grateful.
My lord, because another coordinate bench directed them to defreeze my account within 48 hours.
I do not know. I do not know.
Why are they not
I'm not
pursuing
going
the
like
contempt
that.
application? Let them
Because
do
my
that.
lord, contempt application is also pending. We have, my lord, kindly comes to next
Contempt
page.
for what?
Come to, because they are not defreezing my account.
Contempt of whose order?
Justice Shankar,
sir.
Proceed with that. I am not with that. So you have paid for extension. You have to deposit, comply with
this month
by the end of this month.
I'm so grateful. Man.
Grateful.
This
Disposed.
Yes. Next.
Item number 25.
In matter again disposed of.
25, I am for the petitioner, Your Lordship.
Yes.
No, epitome of the caveat.
Item number
25, Your Lordship.
25. There is a caveat.
Lordship.
Yes.
I have served the concerned learned advocate. This is a suit for eviction of licensee, Your Lordship. Sole defendant died. I have been substituted. I have entered appearance.
না না আরেকটা 12টার সময় ছিল না পাশে না
Item number 18.
Item number 18.
And for the petitioner, Lordship.
Yes.
Lordship, for only not Lordship.
Yes.
Lordship, my
Was engaged. Where is he now?
court number 32, Lordship.
Yes. I've given you time till.
He is not come, Lordship.
Madam, you said that he is engaged in some other course.
Now, still,
Ask him to come at 1.
Lordship, only not for Lordship.
No.
Fix it Monday, Lordship.
Ask him to come at 1. Till how long he will be engaged in that court?
Lordship, only praying for only.
Please ask him to come at 1. Yes.
25.
Yes.
Lordship, suit for eviction of licensee, original sole defendant. I am the substituted defendant, Your Lordship. Lordship, on 12th March 2025, I have entered appearance. Lordship, subsequently on, if Your Lordships kindly come to the page number 35.
Yes. Where is Mr. Shonok Mundol? There's lodged on caveat and not appearing. Where is he? Pass over.
Item number 26.
I am for the petitioner.
এটা রাখুন এপ্রিল সার্ভিসটার মধ্যে রেখে পাস ওভার করে রাখুন
My lord, this is a suit for declaration injunction at the instance of the opposite party number 1. Petitioner and the pro forma opposite party are the defendants.
What is the impugned order?
Impugned order is for permission for making construction over the own land of the petitioner. The fact remains, if my lord considers page 22 of my application.
Yes. There is an application miscellaneous case under order that rule 2.
Yes, my lord.
That now you cannot be allowed.
My lord,
Let
kindly
that be
consider-
disposed of? No. There's
My
an
lord,
allegation
kindly
of
consider
violation.
Page 22.
Yes.
It is the case that the injunction is on Schedule B property, which is a 4 feet by 46 feet land, piece of land. And my entire property is much larger.
Maybe.
And my lord, this is a construction, I am making construction under PM, Pradhan Mantri.
Maybe for whatever reason, violation case is pending against you.
My lord, he has no other place to reside. Only thing is,
I do not know. But you
Even-
should have applied for permission prior to construction. Now a violation case is pending.
it is, my lord.
Application under Article 220.
But I appear for the petitioner. There's a little.
But I have very scary. I have a preliminary point of maintainability.
Let him, Mr. Banerjee, argue it. I'll thrash it off.
Yeah.
What is the preliminary point?
My point
What is the order?
The order of the district magistrate, Lordship will remember. This is that order, my lord, under the unauthorized occupants act. Yes, that matter.
Yes.
I am raising a preliminary point of maintainability. The maintainability, the point in the crux is, my lord, when the person are designated, the authority concerned is a judicial officer, civil 227 will be maintainable. But if it is not a judicial officer, not having the trappings of court, then 227 will not be maintainable.
It could be 226 according to
226 can be. I'm not talking about, but 227 will not be maintainable because it doesn't have the trappings of the court. And I will be, I'm involved with the judgment of the Supreme Court.
I think there is also a larger bank judgment of our court because there was a difference of opinion and thereafter it has been
226, yes, but not 227.
Yes, so that was the issue, whether 226 or 227, there was a difference of opinion.
Thereafter,
now Supreme Court has said
Supreme Court has said it and now followed in 24 by Justice Datta in Supreme Court also.
Yes, one of the reference divergence of opinion was by Justice Datta.
Now it is also followed the Supreme Court and is now said. Now there are two Supreme Court judgments.
Mr. Banerjee, what do you say? Mr.
He can take it on 226. I'm not saying that.
My lord, I can argue it here if he argues, my lord, because 227 would be maintainable because from the SDM's order we came before, my lord, he didn't take that point. Be that as it may, if he takes it.
Mr. Banerjee, whether consent can confer.
No, I am not on that. I am not on that.
Maybe that on that occasion he did not take this point. But
I am not on that. I am not on that. Kindly takes, my lord.
What is the difficulty if you, I can give you, it can be converted to 226.
It can be. Kindly sees, my lord, kindly sees one provision. Why I am saying this in this case is it would be because of my lord supervisory jurisdiction. Well, kindly see takes
it has to be, Mr. Banerjee, it has to be either court or tribunal. So either it should fall within court or tribunals. Then 227.
This has the trappings of a tribunal, and my lord, if it is a provision which is remediless, then my lord, being the High Court,
226 is there, Mr. Banerjee. It's not that you are remediless. The question is whether 226 or 227.
My lord, kindly sees the language once. My lord, I will go. That's not an issue, my lord. Lordship will grant me liberty. I'll go. But then kindly sees, my lord, the provision.
Mr. Banerjee, it is to be decided. Then it is to be hard, both of you. Unnecessary, it will be delayed because you must be having some urgency.
I have.
So that is why. So if you want, you can consider you know those propositions, those judgments.
I know those propositions, but my lord, those are. I know the proposition, but this is on a different fact, different law. That is what I'm saying.
Either way, 226 will be maintained.
Yes.
There's no dispute with regard to that.
No, I'm not saying that.
But perhaps with greatest of respect, 226 won't be because this would be, my lord.
Well, Mr. Banerjee, then you can.
I don't want to, my lord. If your lordship wants me to go before that court, I can go before the writ court. But my lord, if I say for academic purpose, even my lord, kindly sees the provision once. I know that judgment. Kindly sees the provision once.
Public land eviction of unauthorized occupants.
Yes, my lord, kindly sees the provision.
Public land eviction of unauthorized occupants act.
It is a tricky provision. I'll go, my lord, but for 5 minutes for the academic purpose, looks at the provision. Why I say it would be 227 only and not 226.
Not the best time for
5 minutes.
Academic
I'm sure it would take 5 minutes, if lordship doesn't have, my lord. Because the applicant doesn't have a right under the act. Ricky.
West Bengal Act.
Public land eviction of unauthorized.
Yes, kindly sees, my lord, section 7. Kindly see section 7. An appeal from an order made under this act shall lie to commissioner of the division where the order is made by the collector, and the collector where the order is made by an officer specially appointed under clause B of clause 1 and section 2, if this is the time period. Now, my lord, kindly comes to proviso. That the appellate authority, on being satisfied that the appellant was prevented by sufficient cause from filing the appeal, now sees 2. The state government may, on its own motion or on an application made to it by a person, aggrieve against the order of the appellate authority within 30 days from the date of such order on grounds of gross error or facts, or of law, or both of facts and law, call for and examine the record and appeal, and may take such orders thereon as it thinks fit. So where is the remedy? The act does not specify anything. So that is why, my lord, it would be 227 only.
The act gives an appellate remedy. After that,
there is nothing.
No. After that is why 226, 227, both.
Yes.
Now, whether 226 or 227.
That is what I am saying, my lord.
So
In this case, perhaps it would be the superintendent's jurisdiction of 227.
Provided
I know this judgment, my lord.
Because it cannot be said to be a court if you want to bring it within the definition or expression tribunal.
My lord, here, my lord, perhaps, my
jurisdiction.
lord, I am trying to argue something else. My lord, here I am arguing, my lord, when there is nothing in the act, then 227 would apply. Because why I say, my lord, I'll give an example. My lord, under 29A of the Arbitration Act, there is no remedy of appeal. So 227.
That's a tribunal, Mr. Banerjee.
Yes, that's a tribunal.
That is why. That's a tribunal. So it is a tribunal, and 227 supervisory jurisdiction over courts and tribunals. May not be a court, but a tribunal.
But this, my lord, this has the trappings of a tribunal. Lordship has to, my lord,
Mr. Banerjee, that has to be decided.
I am going, but the fact is that, my lord, perhaps see the section, my lord. If there is no remedy spelled out.
Mr. Banerjee, you are right. There is only an appellate remedy provided. After that, there is none. After that, there is none. So now 226 or 227, because two avenues are open to you. So because there are some distinctions within from 226 and 227 with regard to the territorial jurisdiction also.
Yes,
because you may have part of the cause of action. By taking that, you can invoke 226 of a particular court, but may not be 227 of that court.
Yes, but here
might be 227 of that court.
Yes.
So though you may say 226 and 227, both constitutional remedies, even if you do not have any other remedies, you can. But there is some distinction between 226 and 227. Even from the inception, from the jurisdictional point itself.
Yes, but my lord, kindly sees this section, which is very sketchy. There is no remedy. And kindly sees the limitation.
Mr. Banerjee, I fully accept that there is no remedy. But even in that case, whether 226 or 27, that's Mr. Banerjee.
Yes.
It's like,
my lord,
Banerjee.
It's like
both of you are senior, but
no, my lord, Mr. Banerjee is very senior.
that is why-
No, not.
That's why I'm saying
the fact is that you, my lord, kindly consider this is like a concept of SLP, my lord, where, my lord, the jurisdiction is too wide under 227. Since there is no remedy.
Mr. Banerjee, jurisdiction may be wide, court can, suo moto also.
Yes.
I'm not disputing that, but it's after all a supervisory jurisdiction, and upon whom it's only the court and the tribunals. That is why, Mr. Banerjee, you cannot, because in 226, even if a cause of action arose, let us assume, in Delhi, and part occurs here, you can file a writ petition here.
Yes, of course.
But it's not the other way around. Maybe at times, even if a part of cause of action has taken place here, you may not invoke 227 before the Calcutta High Court. Maybe you have to go before the Delhi High Court.
So
that's the difference.
Those are different facts, my lord.
That is why. So maybe both are constitutional remedies, powers are wide, but there are some limitations with regard to 227.
Perhaps it's the other way around, my lord. 226 is little, there are trappings, but in 227, my lord, there are not much.
Unless it falls within, yes, in territorial jurisdiction.
Territorial jurisdiction, of course.
That's the limitation.
That I don't have to suffer here, my lord.
No. May not be in this case.
Yes.
Saying that even by taking part of the cause of action, 226 too, you can come before this court. may not be 227 may not be available to you under that particular.
Because kindly see, it's a very sketchy act. It sets a limitation for the appeal before the collector, but thereafter there is nothing. No word at all.
That is there because with regard to that statute, appellate remedy in most of the cases you will be finding in the Land Reforms Act. You will be finding that while filing an appeal under from an order passed under section 8 and 9 preemption, appeal is there before the district.
In also there are 227 filed.
Provided in the statute. So there is a limitation, but after that, no. After that, you can come before 227 within time, within the
reasonable time. Reasonable.
So, many statutes have this appellate remedy with some limitation, but thereafter you can avail 226 or 227.
Malad then kindly converts this into a 226, Malad. And Malad sends it, Malad, because I have filed it before my lord. And there is no, Malad, I know this judgment also, but this is not on the facts.
When this matter is taken up for hearing, Mr. অন্য জায়গায়
কাদের ওদের?
Yes, এটাকে কিন্তু সই করে এক্ষুনি পাঠিয়ে দিন। Ask your advocate on record to only convert it from 227 to 226. That conversion is to be made. Others you can file because they have to assign a number. Unless
Of
you
course,
state
my lord.
that, they cannot.
It will do it today itself, my lord.
And
Today itself.
acha, to amend the cost title as well as the যেটা amended এটা এই দিচ্ছি না, leave is granted.
Someone up there, my lord, who has a great experience this thing.
No.
Otherwise, this form part, my lord, most of us skip out, my lord. Great.
Yes, next.
Item number 28.
28, my lord, I'm for the petitioner, my lord.
Yes.
In a matrimonial suit, my lord, I'm the wife.
Yes.
Now, my lord,
You are the wife.
I'm the wife, my lord. Here, my lord.
What is the impugned order?
My lord, I'm the impugned order is, my lord, my application for, my lord, submission of additional written statement that has been, my lord, rejected. Lordship kindly sees, my lord, one paragraph of the, my lord, the plaint of dissolution of marriage, my lord, and my written statement, my lord, countering that. And why, my lord, that is necessary, my lord?
What is the suit for?
Well, for the divorce, my lord, for dissolution of marriage. The section 13, my lord, of the Hindu Marriage Act. My lord, kindly, my lord, takes up page number 12 once, my lord. On page 12, paragraph number 4. It's a very short, my lord, application made by the husband. Lordship is looking at.
Yes.
Lordship kindly sees, my lord, how it has been dealt with, my lord, in my original written statement, my lord. Original written statement, my lord, only, my lord, page 15, paragraph number 6, that's the only, my lord, averment, my lord, taken. The respondent, my lord, never suspected your husband in any manner, but the ill motive.
You have only denied that.
Only denied.
Yes, where is your additional written statement?
Yes.
At what stage, Mr. Banerjee? At the argument stage?
No, my lord, at the examination stage. Examination
of whom?
My lord, defense witness. The OPW, my lord. At the examination of the OPW. It's at the belated stage. My lord, I've got, my lord, one, my lord, decision, my lord, that it can be done, my lord, upon payment of cost, my lord.
What?
My lord, kindly sees, my lord, why, my lord,
Can
why
you bypass the proviso of Order 6, Rule 17 by filing an application under Order 8, Rule 9?
For written statement, my lord, the view is, my lord, a bit liberal, my lord.
Maybe.
But kindly
Can you bypass the proviso to Order 6, Rule 17 by way of filing an application under Order 8, Rule 9? Because you are too key. No.
My lord, this decision is of, my lord, 2009. The 2009 decision, my lord.
Yes.
Lord, may I place it, my lord?
What does it say? You can bypass.
No, my
proviso.
lord, it does not.
My query to you is whether you can bypass 226.
Does not.
Proviso to 220.
My lord, paragraph number 10, 11 and 17, my lord. 3 paragraphs, my lord, I'll place.
Development.
Well, this averment, my lord, is not denied, my lord, in my written statement, my lord, would be fatal, my lord, in the suit, my lord, in the fate of the suit, my lord. Kindly considers this aspect, my lord.
What is the, show me the additional written statement.
Additional written statement, my lord, page number 33. Only one paragraph, my lord, is being inserted, paragraph number 3. Page 33. Now, page 34 is the relevant portion, my lord, from the middle portion of it.
This is a new case which you are trying to make out.
Well, that has
And
also,
this is
well, that has also been dealt with,
no,
my lord.
this is also not necessary for the purpose of deciding the disputes in the suit. That's the relevant thing.
Lord, kindly considers, my lord.
Relevant facts
Lord,
cannot be.
my lord, that is the only, my lord, kindly considers, my lord, the plaintiff, my
Because
lord, itself.
what the grounds you have sought for is maybe a ground for getting a divorce that you have not prayed for.
My lord,
It's
that
the
is,
suit of divorce by the husband
By the
against
husband.
you. You are defending that may be a cause of action for you to file a divorce. File a suit for divorce on that ground. Nobody is stopping
my
you.
lord, that is
But
not,
that is not the relevant fact.
that has not been prayed for, my lord, by the wife.
That is why I'm saying.
My lord, kindly
So
considers,
the
my lord,
facts which you are trying to incorporate by way of filing of the subsequent additional written statement is maybe a ground for divorce, cannot be a defense in because his facts are not necessary at the evidence.
My lord, kindly
After
considers
the evidence has
only-
started.
My lord, kindly considers one aspect. My lord, in the plaint, my lord, the husband divorce has been, my lord, sought for only based upon that paragraph. There's
Yes,
nothing else.
yes.
So cruelty, mental
That may fail. Mr. Banerjee, you disprove that will fail. But what grounds you are sought to canvass is maybe a ground for you to get a divorce, but it's not, cannot be a defense against that.
My lord, kindly,
This stage.
my lord, kindly, my lord, this spills over at page 35 as well, my lord. My lord, if this fact is not, my lord, this
seen.
pleading is
This
not there.
cannot also be a subsequent fact. You knew that
Yes,
at
yes,
that point
yes,
of time.
certainly, my lord. This is not subsequent, my lord, but my lord, my lord, that I have also dealt with, my lord, in my application for my lord for additional written
Yes,
statement
yes.
for my
Nothing.
leave. My lord, kindly considers, my lord, that my lord, my application, my lord, starts at, my lord, page. What is annexure D? I just
The husband's evidence has been concluded.
Yes, yes.
Now, at your
that, my lord,
evidence,
after that, my lord, OPW.
cross-examination, your cross-examination,
Cross-examination is yet to start. Chief has been filed.
chief has been
Chief has
filed.
been filed.
This application under
Kindly considers, my lord, one aspect, my lord. Otherwise, my lord, it's fatal to the, my lord, my original.
It is not fatal.
Original
You can file a suit for divorce on these grounds. File a suit for
that is not has been, my lord, prayed for even in the additional WS. But even in the additional written statement, that is not.
That is why I am telling you that may be a sufficient ground for you to file a suit for divorce. That you are not doing. That may be a very good ground cause for in a suit for divorce filed by you. But
my lord, that has not been, my lord, canvassed, my lord, by the petitioner here in, my lord. Kindly considers, my lord, to disprove, my lord, the statements of the husband. My lord, these facts are to be, my lord, brought into. Otherwise, my lord, this will be fatal, my lord, to the case of this.
More fatal if this is allowed. On the basis of this averment,
Unless,
this case will be proved.
even if, my lord,
This case will be proved, Mr. Banerjee.
even if it is proved, my lord, the husband, my lord, unless, my lord, the wife wants a divorce based on these grounds, my lord, that cannot be granted.
That is why these are not relevant for the purpose of deciding. This application under Article 220.
Item number 29, I am appearing on behalf of petitioner lordship. I am praying for some time lordship for taking some instruction. Kindly.
What instruction?
Taking some instruction lordship to the petition.
What is the order impugned? By the order impugned, the go through that brief. I'm coming.
Difficulty is this.
I'm taking up 2 p.m. This is sufficient on the maintainability, nothing more. I'm on the maintainability.
My lord, on 7th January, the learned DRT passed an interim order on based on certain observations. Why the surface actions are bad? Interim order in my favor, saying that why the interim orders, why the surface actions are bad in law. Although it is an interim order, an appeal was preferred against that. Appellate forum, the learned appellate forum made certain observations and remanded back the matter to the learned DRT. Learned DRT at this time, at this juncture, just turned around, negated his own observations, and acted on the basis of the observation of the learned DRT and passed the final order. So learned DRT has already made up his mind, my lord. My lord, I'll come back, my lord. My lord, may I come back on at 2 p.m. or on Monday, my lord? My lord.
Come at 2 p.m. Come at 2 p.m. My lord. Please satisfy me on the maintainability. I will not go into the merits, my lord. Because Shah, you know in your matter I have delivered.
Yes, my lord. But it is something different by
maybe whatever is different. The points which you will be urging here, those are available before the appellate forum. Those are available before the appellate forum. But it's a self-contained code, Mr. Shah. So you need not be reminded.
But the appellate forum has already made up.
Supreme Court times and again has held this.
But I'll come back at 2 p.m.
Come at 2 p.m. 2 p.m. Raghban Eta. Yes. Next.
I beg to appear for the opposite party. I beg to appear for the opposite.
Yes, Mr. Chatterjee.
My lord, objector, my lord, is the petitioner before my lord.
Objector, probate.
My lord, letters of administration. Yes. Now, my lord. Probate. Joint executor. One of the executor is opposing the will. Yes.
One of the he's
joint executor, father appointed. He is now opposing the will. Other sisters have granted consent. Lord, the objector, Lord, I'm telling you, Lord, this is against Lord.
What is the impugned order?
Lord, rejection of my amendment application.
What is the amendment
Lord,
you are
yes,
seeking?
the amendment which I sought for, Lord, are threefolds. Lord, first, Lord, I have indicated that the properties of the testator, Lord, which belongs to the estate. Lord, there are certain agreements entered into by third party and amount of considerations has been received. So, Lord, those amount now, Lord, has to be the estate of the deceased, Lord, which is not there before the probate proceed or the proceeding. Now, Lord, furthermore, Lord, I have said the executor who has approached the court for the grant of probate or letters of administration, Lord, is in the wrong footing or the wrong executor, wrongdoing of an executor, as he has misappropriated or the funds lying in the UCO bank of the testator amounting to rupees 12,50,000. Now, my lord, when they use an objection to my amendment application, they have not denied this misuse of 12,50,000. They have not denied that. Rather, they have also stated, yes, there were certain transactions held by virtue of him having a power of attorney from the testator. Now, my lord, my contention is, my lord, the trial court has misdirected itself in holding that this is not required for, my lord, in a grant of probate proceeding for genuineness of the will. My lord, I saw.
Yes, Mr. Chatterjee,
Yes.
then it's that is what I was trying
Yes,
to
yes.
put that question. You have answered
My
that.
lord, I know, my lord.
In a probate proceeding, what is to be proved?
Now, my lord, genuineness of the will, my lord, no suspicion circumstances, these are all factors.
Whether the will was
Absolutely, my lord, I
by
bow
the
down.
testator, free, sound, mind.
Yes.
So, so
And the
these are the aspects.
and 63 ABC has to be proved.
Yes. So will has to be proved. Those are other things. So nothing beyond that.
No,
Your
my lord,
amendment is not.
that's why, my
regard to
lord,
such
I start by saying this is a probate proceeding.
Yes.
Probate proceeding doesn't end, my lord, on the grant of probate. My lord, it continues, my lord, till the executor is discharged. My lord, on, my lord, filing of, my lord, assets. True inventories and assets.
strategy. Those
Now, my
are
lord,
the things-
for this.
those for that, everything cannot be the scope of the probate.
No, it's
proceedings
not
cannot
about
be
the
enlarged.
scope. It's not about the
And
scope.
yes,
Now, my lord,
it
kindly
was
takes
only
up
with
the.
regard to show me that your amendment is touching upon the genuineness
My lord,
and
kindly
the
takes up the
mental
Indian
or the
Succession Act
physical
for-
capacity of the testator. Yes, other facts no.
Kindly takes up the Indian Succession Act for once.
Show me the amendment first, Mr. Chatterjee.
Right,
Show me the
amendment is on
amendment.
that. Right. My lord, kindly takes up
Amendment.
my amendment application, my lord, at page 25. My lord, the schedule is at page 26.
At what stage, Mr. Chatterjee?
My lord, at the start of my examination, the objector's examination.
Yes, so their examination closed. Yes.
Now, my lord, kindly looks to the schedule of amendment. My lord, may I just play paragraph 7A? That Pareshnath Shaduka was the father of both the parties to the case, and after Pareshnath Shaduka died on such and such, leaving behind his two sons, namely Gorachand Shaduka and Amarnath Shaduka. And during the lifetime of Pareshnath Shaduka, he executed a registered power of attorney on such and such, white such and such for the year 2017 in favor of Gorachand Shaduka in respect of the land measuring more or less such and such situated within Moja such and such. During the lifetime of Pareshnath Shaduka, he entered into an agreement for sale with Joyiti Chaki, daughter of such and such at Green Park on such and such in respect of land measuring about such and such out of 2 acres 50 shoto. That is, opposite party states that on the strength of the registered power of attorney, Gorachand Shaduka sold and transferred land more or less 2 katas 8 cheetahs with the right of 6-foot common passage situated at such and such Mukutpukur road number such and such, and after selling and transferring the said portion of the land, Gorachand Shaduka misappropriated the entire sale consideration money by depriving the opposite party and the said transferred land already included in the last will and testament by the testator Pareshnath Shaduka. That your opposite party states that the petitioner Gorachand Shaduka hiddenly obtained one trade license such and such from Barakpur.
Yes, yes, I've seen that.
Now, my lord, kindly tell us to paragraph 8A.
Yes, yes, I've read the entire.
My lord, 8A, the second paragraph, it would
Show
be.
me the which portion is with regard to execution of the will.
No, my lord, I am not. That's why I say I use a caveat, my lord, saying that kindly takes up Indian Succession Act.
Yes. Indian Succession Act din to.
The testator died on
27.
2017,
Will was much prior to that.
20,000, Mr.
No.
Chairman. How much?
My lord, kindly do not impose anything, my lord. I am already at the end of sufferance.
Running an oil mill.
চলছেই না ব্যবসা।
Those provisions which you have cited, those had to be considered in an application for amendment of this nature. Three provisions of so 5,000 each
No, no,
for each of the provisions.
no, no, no. We are already at the end of sufferance.
Cost-টাকে delete করে।
He
Yes,
must
so-
treat us.
সেটা বাইরে।
Yes, that has to be, otherwise that will be
Every day.
imposed. Please tell me prior to 3:30.
And my lord is taking judicial notice of this.
Yes, 3:30, otherwise that cost of 20,000 will remain.
Yes.
Yes, call the next matter.
Item 31, my lord, I am appearing for the petitioner. My lord, there is a caveat, my lord, I have already served, my lord.
The learned senior advocate, Mr. Mohammad Karim Waris, is out of station. I am praying for not today, Lord.
My lord, Mr. Chatterjee is leading me, my lord. Means he is also, my lord, unwell, my lord. He has not come to court today. My lord, kindly makes it not, my lord, kindly, my lord, the matter may retain his position, my lord.
What is
This
the,
why-
come at 2 p.m., let me see.
No, my lord, my lord, today, my lord, if I am out of session, my lord, kindly, my lord, considers, my lord, may I come back on Monday, my lord.
Monday, but not in this position. And
My lord, kindly considers, my lord, there is some urgency in this matter, my lord. My lord, this matter, my lord, pertains to, my lord, why my order 26 Rule 9 application, my lord, has been kept in abeyance, my lord.
has been paid by the learned advocate for the petitioner.
Well, can I keep it at 2 p.m. Milord? Mr. Chatterjee will. I'll try and ask Mr. Chatterjee to join virtually, Milord. And can I keep it at 2?
Yes, my lord, I mean personal difficulty. I have spoken to Mr. Ghosh. Item number 35. My lord, it's a big matter. Your lordship had heard it. My lord, I'll be not there after 2 p.m. My lord, if it can be taken on Monday. My lord,
With
he
the
will-
consent of Mr.
Yes,
Ghosh.
yes.
It is taken up for the next day in the same position. I have no objection.
No, if he's taken in the same position, my lord, can you take it up on
PM ছিল তো করে দিন, তারপর পাসওয়ার্ড। Yes.
Lordship, 31 I am for the caveator, the learned advocate of caveator, Mr. Mohammad Karim Waris is out of station. I am praying for not today, Lordship.
Which
Milord,
item?
31, Milord. Milord, I am the petitioner, Milord. Mr. Chatterjee is leading, Milord. He is appearing virtually. Milord, can it be, Milord, not today, Milord? Mr. Chatterjee, if he can appear, Milord, Milord, there is some urgency in this matter, Milord. Milord, Mr. Chatterjee is appearing, Milord.
Yes.
Item number 18.
Lord,
31.
Number 18.
18, who is appearing? None appears for the petitioner at the time of
Your Lordship, I am
Milord, I appear on behalf of the opposite party. Milord, I apologize, Milord. I could not appear at the time of first.
Yes.
Milord, Milord, only one thing, Milord. Mr. Chakravorty is appearing in the learned trial court.
Sir?
Chakravorty is appearing.
Baripur Court.
Yes,
Baripur.
Since I'm not inclined to take up this matter on personal.
Well,
Yes, Mr. Shah.
My lord, this order is, my lord, passed by the learned DRT. Order is applicable under section 18 of the Surface Act. And there are numerous judgments. I have also cited some judgments when I have done matters before my lord, appearing on behalf of the bank or financial institutions, that there is an alternative remedy, and that is the efficacious remedy where the petitioner may approach. But my lord, this case may be of slightly different, that I would like to point out before my lord. My lord, here in this matter, my lord, I am not challenging that the learned DRT failed or did not consider the irregularities committed by the bank or the illegalities committed by the bank while acting under the Surface Act. That I am not challenging. The learned DRT failed to take note or odd in fact or in law by not considering the illegalities committed by the bank. My challenge is on a different footing altogether, my lord. My lord, I would like to invite your my lordship's attention to the order dated 7th January 2025, which is starts from page 85 onwards.
Page 25.
85, my lord.
85. Yes.
My lord, I have filed one essay, that is Surface A application, before the learned DRT. And during the pendency of the Surface A application, the bank obtained an order of the DM under section 14, 11th December 2024, bank obtained that order. Challenging that order of DM, I filed one interim application, IA. That was taken up for hearing by the learned DRT. My lord, I would like to point out not the entire order at this juncture, my lord, only the portions, my lord, some portions. My lord, kindly turns to page 86, my lord.
Yes.
The last paragraph. What was the view taken by what was the opinion found by the learned DRT while passing this interim order on 7th January 2025? I have taken a close look at the purported order dated 11th December 2024, passed by the learned DM, not 24 Parganas. It appears that the demand notice under section 13(2) is dated 2nd March 2022, and such demand notice was published in two leading newspapers, one in English Business Standard and another in Bengali vernacular Ajkal, on 6 July 2023. As per provision of section Rule 3 of SARFAESI rules, it provides that where authorized officer has reason to believe that the borrower or his agent is avoiding the service of notice, or that for any reasons the service cannot be made as aforesaid, the service shall be effected by affixing a copy of the demand notice on the outer door or some other conspicuous part of the house or building in which the borrower or his agent ordinarily resides or carrying on business or personally works for gain, and also by publishing the contents of the demand notice in 2 leading newspapers, one in vernacular having sufficient circular in the locality. So this is the contention of the Rule 3 of SARFAESI Interest Enforcement Rules of 2002. So I am not on this, that bank did not follow Rule 3 and the learned DRT did not look into it. I am not on that. But learned DRT was of the opinion that the bank did not follow Rule 3 while publishing this demand notice. Thereafter, my lord, the next paragraph, I am reading, my lord, the last portion, the next paragraph. Let us take a look at the publication of the alleged demand notice under section 13(2) dated 6 July 2023. In the publication in Business Standard, it is stated that the respondent bank is invoking the provision of section 13(2) of SARFAESI Act and called upon the borrower and guarantors to make payment of an amount of such and such. But from the publication in Ajkal, it appears that the respondent bank is withdrawing the measures under section 13(2). Publication in Business Standard and Ajkal are contradictory and antagonistic to each other, and question remains which publication is correct. So this was a view already taken by the learned DRT while passing the order dated 7 January 2025. Thereafter, I am reading the last paragraph of this page, my lord. Moreover, it appears in the recall notice dated 1st November 2021, there is mention of date of NPA as on 29th May 2021. But in the demand notice dated 2nd March 2022, published on 6th July 2023, there is a mention of NPA date as 30th May 2021. So there is a clash of date of the classification of NPA in the recall notice dated such and such, and in demand notice under section 30T published on such and such. So that was the opinion already formed by the learned DRT. Now, my lord, this order was carried in appeal by the bank. My lord, the appellate order starts from page 90 onwards. I am not troubling, my lord, with the entire order, but only just few portions of the order of the appellate court.
Yes.
Which, my lord, I kindly sees page 92, my lord.
Yes.
The second paragraph. One interim application being IA number such and such was filed by the respondent for the relief of quashing of the order dated 11th December 2024 passed by the learned district magistrate under section 14 of the Act, wherein in para 12 the applicants dealt with the notice under section 13(2) as well as the NPA, but at no place the ground of publication under section 13(2) notice in Bengali newspaper where the word Pratyahar was written was taken. Another ground is taken that in the loan recall notice issued by the appellant bank dated such and such, the date of NPA was mentioned as 29th May 2021, but in the demand notice dated such and such, it was shown as 30th May 2021. So there is a clash of dates in two documents. Accordingly, IA was filed. Now it appears that the date recovery tribunal taken into consideration two grounds as referred to above and please and pass the interim order for maintaining the status quo by the appellants. Now, my lord, I would request my lord to skip over. Kindly comes to my lord page 93. Further, it is submitted that the date of NPA in the loan recall notice has no bearing on the date of NPA in the demand notice under section 13(2) dated 2nd March 2022, which have to be taken into consideration in accordance with law. Now, this judgment was placed by the bank. The counsel appearing from the bank placed this judgment of L&T Housing Finance Limited versus Trishul Developers. This judgment is on the point that if there are some small typographical errors, that will not nullify the SARFAESI action. That is on this point. Now, on the next page, very next page, my lord, the learned DRT now forms the opinion, my lord. 94. Hence, my lord, I'm reading, these issues have also to be considered by the learned debt recovery tribunal at the time of final disposal of the security application. Hence, the findings recorded in the impugned order dated 7th January 2025 are based upon technical and inadvertent mistake and could not be made basis for consideration of the security application. So this opinion was formed that the order which was passed, 7th January order which was passed, where the learned DRT categorically held that the publications, contents of the publications are contradictory, dates of NPA are contradictory, and all these points are categorically held by the learned DRT. Now, learned DRT is saying these are very technical and inadvertent mistakes. Learned DRT should not take into consideration of all this. So now learned DRT, what my lord has done, my lord.
But you have not challenged this order.
I have not challenged this order.
You have accepted this order.
Why I was under the impression, my lord.
You have accepted this finding,
my lord.
So now you cannot challenge before any forum.
No, my lord, this order was basically an order of remand.
Maybe all findings you have challenged.
No,
So it's
what
not now to challenge this.
Now what happened, my lord? Normally what happened?
Accepting this, you are proceeding.
My lord, what happened, my lord? In case of an order of remand, normally the court
That is
below.
up to you. What is the effect of the order?
The court below is, my lord, knows.
That remains you have not challenged. So all observations, all findings are there.
My lord, court below is not supposed to be influenced by the observations of the higher court.
That no, there may be two circumstances. One is while remanding, open remand, court says no, don't be influenced, you proceed. In some cases of remand, in the light of the observations that is being made. So it's with observations. And you have not challenged that. You have accepted that. Nothing remains then in the civil revision application.
And now, my lord, what happened? The learned DRT has now totally turned around.
Could not have, because you have not challenged this. You have not challenged this.
Negated this, and now if I go back to the learned DRT,
yes, could not have, because you have accepted. It's binding on the tribunal. Tribunal could not have taken up. And now also you cannot reopen this. It's binding between the parties.
Yes, my lord. But now if I go to learned DRT, my lord, the same result will.
Here also I cannot reopen this because that order finding is against you. No choice is
because ultimately this order is order of remand.
Whatever it might be, but with those observations, not challenged.
My lord, may I come back on Monday with some decisions to assist my lord?
No decisions are necessary. If you want to press this, I'm on that these findings are binding upon you.
Because my impression was that.
Or if you want to try your luck, appeal, I can give you that liberty.
My lord, may I take instructions and come back on
what instructions?
Monday? Only a date may be given. A date on Monday, my lord. I'm not paying for any further accommodation, my
No,
lord.
not on Monday. You have argued, sir. Today you have argued. I have given you.
Only instructions from my client.
No, instructions is not required. I will pass an order. Instructions, if you want to withdraw, I will give you that leave. Order is, I'm not entertaining. That order will be there. Sir, you are doing regularly this type of matters. While appearing for bank, you are saying no. 227.
It is something on a different footing, my lord.
No different footing.
Here the learned DRT
no
has already
footing. Section 15 order, challenged in DRT, failed, straight away coming here. Deposit the pre-deposit amount here, I will consider it on merits. Deposit the pre-deposit. Deposit the amount, I will hear the 227 application. Cannot run away with that.
No, I will not run away.
Constitutional Court also can.
Can, my lord.
Direct.
Can
So
direct.
that if you are willing,
Can
to,
direct.
I will consider this on merits.
Well, for that reason, my lord, may I come back on Monday? I'm only seeking for this indulgence, my lord. Only this amount indulgence.
You can pre-deposit, you can go there. Ashun, this application under Article 227 of saying that
That item 18, just now called at 2 p.m. I thought that that will be called after this because it was a continuing matter. Kindly note it, right? I thought that this will be called after this, but it was called prior to this.
your junior was also not there.
Yes, my lord, it's my mistake. We were,
Nobody was
we were
there.
under the impression that after this continuing, it will be taken. It's my mistake, but I pray for it.
Yes, yes, Mr. Gupta.
My lord, this is against order passed by consumer forum. The difficulty which has cropped up that, may 1 minute, also will go to the impugned order. The decree was modified by national forum.
The decree modified by the
Passed
National
the
Commission.
learned judge
Yes.
was modified by state forum and further modified by national.
Ultimately, modification by the National Commission holds. Yes,
The
thereafter.
modified part is only, the modified part is only that with page 18 is the modified part.
Page 18.
This is only that in so far as extra work was done with respect to the flat,
Who are you?
my lord, I am the developer from whom he has 400 square feet flat is the subject matter.
Yes.
With regard to extra work which was done by this judgment debtor, my client petitioner, they will pay. And this extra work will be decided upon appointing a commissioner.
That's
by
the modification by the National Commission.
To this extent that he will pay for
All right.
extra part, and subject to this, the deed and this will be executed.
Yes.
So this subject to makes a precondition that he will pay me for this extra work pursuant to the order of decree, and I will correspondingly execute a deed in his favor.
Yes.
Page 18 is the modified part. May I trouble your lordship only
Yes,
to look
page
one
18,
paragraph?
yes.
Since the case of the petitioner is that the extra work has actually been executed, the concerned district forum is directed to appoint engineer to compliance of the order of the state commission to assess the cost of extra work, if any, executed by the petitioner. This will be done by district forum after notice to complainant. The amount so assessed by district forum shall be paid by the complainant respondent in terms of order passed by state commission. This revision petition is disposed of, accordingly made clear that possession will be given and conveyance deed will be executed only after the price of extra work, if any, executed is paid by him to respondent.
Yes. What happened after this?
Execution proceeding was pending. I have been directed, my lord. The court has directed police help for taking possession. I only submit that
this has not been paid.
My lord, with regard to payment, an ex-party commission was appointed, which I challenged before state forum. And state forum, because did not interfere, I came up before this court. And that CO is pending before this court. That CO number 1672 of 2024 is pending. Both of them can be clubbed up and disposed of because it relates to order passed in the execution proceeding itself. I am bound by the decree undoubtedly, but it says that as a condition precedent, you do this and it will be executed.
So commissioner was appointed.
Appointed.
So what is your objection with regard to the report?
My objection was that the commissioner has not given me any notice and it was not done in my presence. According to commissioner, the dispute is that 50 or 55 square feet he has carried out. According to me, it is 150 square feet. The order was that it will be carried out in presence of commissioner. If your lordship can also, my lord, appoint anybody at my cost, and this can come to an end, because the only condition precedent is that he will reimburse me with that and correspondingly I will execute it. Therefore, it cannot be read in isolation of that. Because once the decree is modified as a condition precedent, he needs to pay and only thereafter it has to be deposited. The other revision against
So,
reservation.
Mr. Gupta,
I'm sorry.
this amount of 55,890 which was assessed, was it paid to you?
No, it was deposited before the forum.
Why it did not appear before the commission?
Because commissioner did not give me any notice. He carried out ex-party.
No, after that the proceedings.
Immediately when he submitted report, I filed an objection against commissioner report saying
that the order directs that it has to be done in my presence.
All right, then
Because it was not done in my presence, I prayed for directing the same commissioner to carry out in my presence. I will comply with the order, but a commission as directed should be done jointly. This was pending. This was not entertained, for which I went to state forum and consequently filed a
what is
division.
the claim according to you?
My lord, according to me, according to my client, it is 1,55,000, and the claim directed which he has paid, sorry, my lord, 55,000. So there is a shortfall according to my client of 1 lakh, of which measurement has not been taken. If your lordship can appoint, my lord, anybody.
Mr. Gupta, this extra work, why extra work? That was
There is an agreement for sale. Agreement for sale.
pursuant to their
Their requirement.
Show me that they asked you to do those.
My lord, to that extent, there is no dispute.
Where is that?
May I just indicate? The commission.
Mr. Gupta, now it's the area.
No, no.
So the area according to the commissioner, it was 40 square feet, you are saying 150
My
square
lord,
feet.
to that extent.
The works which you had to do.
No, the dispute which is falling from your lordship, that is not involved here. It is only relating to quantum, that whether it is 55 square feet according to the other
Yes, that
side,
is why.
or it is 110 square
That
feet.
is why, Mr. Gupta, the root thing is the requirement, whether it was 150 square feet or 50 square feet.
That will not arise in my case, because I say, my lord, why subject
Yes,
to
where is that
55 square feet?
CO 1670 is
That
appearing.
No, I was.
Where is it?
My lord, এটা কি পেন্ডিং আছে কোন কোর্টে জানো? কোন কোর্টে? এই কোর্টে। মানে এই কোর্টে?
It's appearing in the list.
It is না এই কোর্টে রান করছে মান্থলি লিস্টে। আইটেম নাম্বার বলো।
167.
My lord, I am giving the number, my lord.
1672 is the CO number. Is it appearing in the list, combined list?
কোথায় আছে এটা? মানে কোন কোর্টে কি রান করছে? It is, my lord, showing court number 6, but আছে তো বলো নাম্বারটা। My lord, it is listed, I am giving the number. It is in monthly list, I am giving the number, my lord.
Yes.
Within 1 minute, I am giving the number.
Ashok.
নাম্বারটা জজ সাহেব জিজ্ঞেস করছেন।
By the order impugned, the Yes. Yes.
My lord, I beg to appear, my lord, on behalf of the petitioner.
Yes. Yes.
My lord, your lordship would find in a suit for cancellation of a deed on the ground of encroachment, my application under Order 26 Rule 9 has been kept in abeyance. Kindly have a look at the last line of last line of the impugned order.
Has been kept in abeyance.
Yes, my lord.
Show me your application, which page?
My lord, page 102. Kindly have a look at paragraph 3 and 103. And kindly have a look at the points of commission. Lordship will find that at page 106.
Mr. Chatterjee, how have you described the encroached portion?
Miller, in a schedule in the plaint.
Which schedule?
Kindly have a look at page 48 and kindly have a look at schedule B.
48.
Yes.
48
I'm
is
sorry, it's the prayers are at 48. Miller, kindly looks to the prayer once.
which prayer relates to this removal?
Yes, I'm exactly showing your lordship that. Kindly have a look at page 48 and then 3. A degree of declaration that the plaintiff is the co-owner along with all rights over the passage as described in Schedule B herein below duly identified and delineated for the egress and ingress. And the said private passage is also meant for the common user.
No, that is but no case of removal paid for.
Yes, yes.
Where?
In Milord, there's a question of encroachment.
Yes,
cancellation is 6.
So you have to pay for removal of that encroachment.
Yes,
Where,
yes.
where
No,
is
we
that?
have paid for cancellation of the entire document.
No, document is one thing. So for investigation is not necessary. So according to you, there is an encroachment. Where is prescribed the encroachment?
Kindly looks to 7. Description of encroachment, I'll give you a lordship. Kindly looks to paragraph 17 in the plaint at page 32.
Paragraph 17.
And the description of the encroachment, my lord, is Schedule B.
Page 32, paragraph 17.
17. Page 32 and the description of encroachment, my lord, is page 51, Schedule B. My lord, I am not even praying before your lordship to go into the merits. The learned judge hasn't.
No, but only one thing, Mr. Chatterjee, in order for an application to be maintainable, there has to be a case of encroachment being made out.
That's exactly what I showed you, lordship.
You described it. Before that, it cannot be.
That's why I showed you, lordship, lord, paragraph 17. There are other paragraphs as well describing the encroachment.
The passage has been described, encroachment, removal not paid for, Mr. Chatterjee.
But this is not an encroachment like they have made construction over that part.
So,
it's not an encroachment like that. It is an encroachment where, my lord, a private passage is supposed to become public. It's because my private passage is now supposed to become public. It's a little different from an actual encroachment.
Yes, but whether it's a private passage or a public
in the suit, in the suit.
So that cannot be.
No, I'm not on that. Not on that at all.
So what are the points? How can it be decided now?
Kindly have a look at the. I am not even asking for a decision. I am saying that my application needs to be heard on merits.
Yes, Mr. Chatterjee, what is the difficulty? The learned trial judge has said that after the evidence, no difficulty because it's.
This is the piece of evidence that I need. After the evidence, there is no question. Milord, this is the piece of evidence that I need to prove my case.
Yes, but
If I made out a case of encroachment, whether there is encroachment or not,
Mr. Chatterjee, encroachment, according to you, it's an encroachment by way of construction or by
yes,
something else.
there is, my lord, if your lordship sees, there is a deed which says that this is mine and that is his. I am saying relay the property. Relay the property.
For what purpose? It's a dispute with identification. You have not.
No, there is that is the main problem.
Wherever
I have that's my problem. Because then I will have to show your lordship the entire plane. My lord, if your lordship, I was trying to cut it short. If your lordship remands it back and sends it, then if I have to show, then the entire plane needs to be placed before your lordship.
Because may not be the entire plane, because what's the
My lord,
nature?
my entire plane is necessary here because of the nature of my lord, the encroachment is a very unique thing which your lordship, I don't think, my lord, has happened before. Now what happens is a person who is influential wants to take away, my lord, from me the property which belongs to me.
Yes.
By way of encircling it in a manner where, my lord, I will not be able to use that property. Encroachment can be two types. Encroachment can be, my lord, that I have come into the property on my other side and, my lord, I make a construction. Very well. The other part of encroachment which has happened here is my property is X. He is encircling his property in a certain way so that, my lord, Y comes into X. That is why I have said relayment of X and Y.
Mr. Chatterjee, where is that case made out?
There is.
Yes.
Kindly turns to 23.
Now, Mr. Chatterjee, according to you, as it appears from your submission that there is a passage.
Yes.
So you have said that there is a passage which exclusively belongs to you. Now they are trying to say, no, it's not your exclusive passage. It might be a passage or
they are taking away that passage into them. This is my specific case.
To them, it's not, you do not have a right over that passage. They have a right over that passage.
There's a problem with respect to identity as well.
Where is the
the entire plaint is that. Entire plaint is that. Turns to 23. 23. And then kindly turns over.
Not at this stage. Let the evidence start. May not be at.
There is no stage, my lord, in my respectful submission, subject to what your lordship says.
There may not be any, because Mr. Chatterjee, liberty has been given to at the appropriate stage of the suit.
No, there is no appropriate stage. This is where I am on. Even injunction stage, my lord, this is required.
Can be done, but Mr. Chatterjee.
It's required.
Yes,
Lord, I have an order of injunction in my favor.
Yes.
I have an order of injunction from the Honorable Division Bench. Even during the final hearing of the injunction, my lord, it's required. In my respectful submission, subject to what your lordship says.
Your case here.
It is. That's exactly what I want to show.
Application under Order 26, Rule 9, that it is for that purpose.
My lord.
For the purpose of injunction, show me that.
My lord.
That it is for the purpose of deciding the injunction. 9. That is what I'm saying.
I am not saying that only for the purpose of injunction. I'm saying for every purpose, my lord, for injunction, suit, every purpose.
There is no dispute. But what is the case here? It is still.
Kindly have a look at the plaint once. Kindly have a look at the plaint. It's very important. Kindly turns to paragraph 4. That the said private, my lord, may I come back on Monday? Difficult for me, little difficult. I come back on Monday.
But I have no objection, my lord, but they are enjoying a injunction order, my lord, since 2021. Injunction
that was on a contested hearing passed by the division.
What is the challenge here? I'm not considering the injunction.
And the second thing, my lord, the learned court's view is that, my lord, they are fishing for evidence now.
That cannot be. In an encroachment matter, there cannot be. That's completely perverse.
The common passage, my lord, that everyone using this. This is from Vaishnavgada Road till the bank of a pond.
After some argument, Mr. Chatterjee, learned senior advocate appearing for petitioner submits that since he is suffering from fever,
that time,
since he is suffering from fever, it is not possible for him to make an elaborate argument through virtual mode today. First up, the opposite party is represented. First up, list this matter. When Monday or Tuesday?
Monday.
Affidavit of service, Your Lordship.
Monday. Yes.
Grateful, man.
Court today is taken on record. Yes, call the next matter.
I'm obliged, my lord.
32.
Mr. Bisha is appearing for the petitioner. Mr. Bisha, Ratul Bisha is appearing for the petitioner. He has some medical emergency. And moreover, there is a caveat. I could not serve to the learned advocate on record. I have called him. He told me that up to Monday he cannot receive. After Monday he can receive. He is not
The
in
learned advocate appearing for the petitioner submits.
Not to the I have no green matter. Green matter not to the I have no.
On the prayer of the learned advocate for the petitioner, hearing of the civil division application stands adjourned. Call. That matter.
I'm for the petitioner.
That matter.
No. But that is not whether it be order 9 rule 9 applicable when the suit has been dismissed in presence of the plaintiff, it is not covered by order 8 rule 9. Order 9 rule 8. But that's your lordship one judgment, your lordship for Supreme Court Kutikuram. I have gone through, but the citation is not there. But I have got several judgments that when in presence of plaintiff, it is in order 9 rule 9 is not applicable. Your lordship
This
has
application was under order 9 rule 9.
Lord?
No, this was what happened.
Yes.
It was dismissed for default.
Lord, default, Lord, but in presence of the plaintiff. He
in the presence of the plaintiff, how could it be dismissed for default?
That's why I have come before your lordship.
Plaintiff was present.
Yes. Took steps, thrown cause. So similar matter has been entertained by my lord, I am told, that what will be done? This is that's why. Lord, the caveat was lodged. Repeatedly they are not appearing. I have served.
This is for the first time.
Yes.
All right. But there's no question of any interim order, Mr. Ghosh. Suit has been dismissed. What is the question of?
But Lord, they will change the nature and character of the
by the order impugned.
Number 35.
35 is that matter?
That matters.
Yes, 35, my lord. I am appearing, my lord.
Not today. Yes, next.
Lord, your lordship, it will go down. Lord, injunction has been.
No, it will.
Lord, kindly take
Yes.
it, Lord.
Well,
Takes it up on Monday, my lord. I have no difficulties.
yes.
Stand at the top of the list, my lord. Since Mr. Ghosh wants to move and it is my
Yes, yes. No, no, all right.
grateful, dear lords.
Item number 1259.
Nasir, I am for the petition, and though I have already served the copy upon the opposite parties. Is the affidavit of service they have
Did you
received.
serve?
I have served long before that
No, no, but for upgradation, did you serve?
upgradation. It is in the list. See, it is known to them.
How it is known to them?
Because the party concerned has already get the information from myself. He has been informed that this matter is running in the list. That I have already told him.
Who is appearing?
Their advocate.
Where is the notice for upgradation?
Notice is there, Lordship.
Where is that notice of upgradation?
I mentioned it and
Mentioning,
that
how do they know?
that I will.
Sir, it is appearing in 1258 in the monthly list today. It is being taken up. How do they know, sir? The learned advocate appearing, filing the affidavit service. Every service filing code today is taken on record. So,
I beg to appear for the opposite party in the petition in the first matter, my lord. Yes, sir. Mr. Mukherjee is appearing, my lord. Mr. Probal Mukherjee is leading me, my lord. He was waiting for this matter yesterday, my lord. May I prefer a short passover, my lord. Just short passover.
Passover. CPM have a
Bench.
bench. Mr. Bench.
Well, let this matter retain its position.
Passover next. Takun poretta. Yes, 1269. You are appearing. None appears for the petitioner at the time of call.
To 84.
Petitioner.
1284, yes.
It's a matter for expeditious disposal, lordship. But the
Expeditious disposal.
on the last date, your lordship has directed to serve a copy because of two reasons. Firstly,
Expeditious disposal.
yes.
Yes.
This is my affidavit of
Who are you? Husband?
I'm the wife.
You are the wife?
Yes. Section under section 24, the application was filed for bringing for a decree of nullity. In that application, as a petition for alimony penalty.
So you submitted that a sum of rupees 3,90,000 is due.
Right now, more than 4 lakhs.
So they have not paid.
No lordship.
So you want expeditious hearing of the suit.
I have no opportunity. I have apart from that, I don't have any remedy as because from 2015 it is pending lordship.
This application under Article 220.
party, my lord. This is the third occasion when the petitioner does not give us any notice. He gets the matter.
This matter was
Well, as it is, there is no interim order. In the last matter, every service may be kept on.
every service filing code to this taken on record. Hello, Elizabeth, none appears. Yes, call the next matter.
1307.
1307, I am for the opposite party. This matter in respect to execution case that has been already done. We have received the possession, so I think they will not take any steps. We have received the possession only. I was for the landlord. I am for the opposite party.
This matter was mentioned citing urgency. First of considering the urgency pleaded, this matter was fixed. However, when this matter is taken up for hearing, none appears for the petitioner. First of Mr. Chattopadhyay, learned advocate, appears for the opposite party and submits that the opposite party has already received possession through police help.
Yes, ma'am.
First up, it appears that the petitioner is not interested to proceed with this application any further. First up, however, since the petitioner is not present, CO number such and such stands dismissed for default.
Yes.
1312.
1312. This matter was mentioned citing urgency. Considering the urgency pleaded, this matter was fixed. First, however, none appears for the petitioner at the time of call. No accommodation. Yes, Mr. Banerjee.
From an order passed by the National Commission, National Consumer Protection Commission, refusing to entertain an appeal because of there was 55 days delay in filing that. 55 days delay in filing. I know, if my lord looks at the application for condonation of delay, the application is blissfully vague. But my lord knows this is always drafted by someone, not by the litigant himself.
Commission has the power to condone delay.
Yes, did not condone the delay.
By the order impute the
Can you just have a look at the order and the underlying threat in the order?
Section 5, unless there is no proceeding in the eye of law. That's the difficult.
But there are decisions, I'm not carrying, but my lord knows. Even in an appeal, without section 5 being allowed, my lords have been pleased, to pass stay of operation of the order impugned the appeal. In exceptional circumstances. Here, I am exposed.
There is a decision, one decision.
There are three. I could come across three. Following the one which my lord is referring to.
Have you brought the decision of Justice Tandon, considering all this?
Yes, yes. That I have come across, but
that's against you.
But that leaves a space for these kinds of matters. Leaves a space. It's not that it's air sealed or what is.
All cases, Mr. Banerjee, appeal, condonation has to be in an appeal. So there has to be an execution
Appeal is
proceeding.
to be bound.
So in all matters, if that is construed in all matters, mechanically stay has to be granted. That cannot be the law.
Right. my lord has granted us liberty to communicate, my lord, this order.
Yes, then communicate that order.
Grateful, grateful. Grateful.
My lords, kind leave my lord, my lord, before my lord console the list, my lord, a review matter, my lord, on the last occasion, my lord had directed to exchange affidavits that has been completed. And it was supposed to appear after 2 weeks.
This bench.
Before this bench, however, it did not, my lord. I am mentioning a date may be fixed for hearing of it.
All right, hand over the slip.
I'm so grateful.
Yes.
Yes, my lord, kindly seize my lord's last orders, my lord.
Yes.
My lord, there was a, my lord, direction that the papers of the first miscellaneous appeals had to be tagged, my lord.
Yes. Yes, chef. First miscellaneous appeals that have been tagged, I've told.
And my lord, there were also direction for the review applicant, meaning thereby asked, my lord, to file copies of the special leave petition upon serving a copy, my lord.
Because that both of you said that it contains all the documents.
Yes. Now, my lord, the bone, my lord, that we have prepared, my lord, but we couldn't file in the department.
No. I think your junior
Yeah,
mentioned this.
one of
We told, yes.
Well, you've served on my.
You have served them.
Yeah, you've served. Yeah, I don't know the bulls.
Yes, Mr. Bogdan.
Now, my lord, why a review? Because, my lord, our case for, my lord, admitting the review.
Mr. Bogdan, before you start, show me those two disputed documents.
Yes, my lord, that is the
I
thing
think
I
I
show.
should take note of that.
Kindly seize, my lord,
before
page 64 of the SLP.
Page 64.
Yes, my lord.
This document will be sufficient, this paper book, We need not go into other documents.
So far as the review is concerned, this is sufficient, my lord.
The order under review is here, no. Could have
That's in the memorandum of review, my lord.
memorandum of review. You could have included that, so we could have.
There, should be there, should be there.
It is here.
Yes.
Where is that?
My lord, that would be, my lord, kindly seize the impugned judgment at page 1, my lord. It's after the synopsis, the list of dates. Page 1 টা বেরোবে না কারণ অনেকগুলো পরে page 1 এখানে। My lord, it would be after, my lord, the list of dates after the synopsis.
Oh, that is here. Oh, all right. So we can proceed on the basis of this only.
Yes.
Acha, please show us the disputed those two documents.
Kindly seize, my lord, page 64.
64.
Yes, my lord. My lord, this is the document which was relied upon.
Which was relied upon.
Yes.
But you say that this was not part of the writ petition.
Yes.
Let us take note of that.
Seize, my lord, the date.
Page 64, not part of writ petition.
Yes.
But relied upon.
Yes.
In judgment under review.
Yes, my lord.
Mr. Ghosh, any dispute on this factual position?
Not there, my lord. How can I tell, my lord?
Copy of the writ petition, Mr.
Writ petition, he is saying this is relied upon. I do not know.
So that is relied
Mr.
upon.
Ghosh, the writ petition copy must have been served upon
Must
you.
have been who relied upon. I cannot say who relied upon. It was not there. That's his case.
No, what is your case? It was in the writ petition because writ petition, Mr. Ghosh, there cannot be a dispute on this.
No, there
Whether
cannot.
it is a part of the writ petition or not.
Lord, it was not part of the writ petition. I am told. my lord.
That is, it was not part of the writ
This
petition.
is relied upon, not the document annexed in the writ petition.
So that is right. Mr. Bordha, I have recorded only thing, not part of the writ petition, but relied upon in the judgment under it. You have only recorded that. And what is the other document? Which
The other document which was relied upon, my lord, is at page 181 of the, my lord, of the FMA.
No, in the paper book.
Paper book, that would be at page 63. Kindly see page 63.
Yes, 63 was part of the writ petition.
Yes.
But not relied upon in the judgment under review.
Because, my lord, the problem was with the same dates.
No. That is so. These are the two vital documents. So,
my lord, our
that is why
contention,
I wanted to identify these two documents. Then we have to test the correctness of both of your submissions on the basis of.
Yes, my lord. What I say, my lord.
Please give me a minute. This was part of writ petition.
In fact, my lord, that
but
was
not relied upon.
Yes. This
but not referred to.
Not referred to, my lord, because I would also show, my lord, that it can 599, na? My lord, the mandamus appeal.
So, yes.
Lord, let me also be clear in my conscience, my lord. The mandamus appeal, which was registered, my lord, as MAT 1710 of 2015, subsequently renumbered as FMA 4689 of 2015. My lord, there we filed a CAN 599 of 16. In page 181, my lord, this document finds a mention.
Of document?
This, my lord, page 63 of the paper book of the SLP, my lord, which we say was a part of the writ petition.
So page 63 was not part of the writ petition.
Page 63 of the SLP was a part of the writ petition. Page 64 was not.
Yes, so I have recorded that.
So page 63, my lord, of the SLP corresponds, my lord, to page 181 of CAN 599 of 2016, which was filed before the appellate court.
No, appellate court is by way of an additional document.
No, it was a part of the petition.
So stay application. Can is a stay application.
Stay application.
All right.
So My reason for placing this
So
before my
page
lord
63 is also part of can
Milord 599 of 2016,
599 of 2016,
filed in connection with MAT 1710 of 2015,
MAT 1710,
1710 of 2015,
yes.
which was Milord renumbered as FMA.
That is the FMA.
Yes.
That is the FMA.
Why I show this, Milord, is just to Milord indicate that this document was before the appellate court as well. The judgment under review, which was passed in the appeal, this document was before the appellate court when this was passed. But this document was not relied upon. Milord, some inadvertently, Milord, another document of the same date was relied upon, but it must have been handed over by any of the, Milord, the arguing counsel.
That has to be. Otherwise, how can it form part of the records?
Absolutely, Milord. Must have been handed over by any of the arguing counsels, Milord. And that document was relied upon. Which we said that document was totally extraneous, Milord, to the matter in issue.
That was never taken on record for body.
And in fact, Milord, this document has not been even, Milord, reference to this document this at page 63 is not there, Milord, in the operative portion of the order, Milord, which is sought to be reviewed. Only, Milord, the letter which is at page 64.
But one thing, Mr. Bordhon, it must have been according to you. Referred to by either of the parties. We are not saying who. But in the presence of the other side.
Yes.
Not objected to. Not objected to.
Absolutely.
At the time of.
I bow down. I bow down.
So maybe not by way of a formal application, but the
that this document was before the honorable court, Milord, is admitted. Accepted, Milord. We have no.
And if we apply the provisions of Order 41 to 27B, if a document is relevant or necessary for the purpose of delivering or pronouncing the judgment, that can be taken into consideration.
True. But, Milord, the issue then hinges, Milord, whether that document was necessary for the proper and necessary adjudication.
So now it boils down to the fact that whether this document
would have looked into.
Yes, was a necessary document
I bow down.
For the purpose of pronouncing the judgment. And second is a very important thing. What is the effect of non-consideration of page 63?
Yes.
That is precisely my ground of review. The document which was sought to be relied upon, which was required to be relied upon, had not been relied upon, but another document being the same date had been relied upon. But this we say is an error apparent on the face of the record. We don't have to traverse longer. I'll just show from the impugned order that this document at page 64 was relied upon. If not from the order, I can show that this page 64, the document at page 64, has been relied upon, and 63 has not been relied upon.
64 has been relied upon. I think Mr. Ghosh will also not dispute that.
Cannot.
Are you disputing?
The order relies
64
upon
was
the
relied
date
upon.
of a document. The order relies on a date of a document. Document with a date mentioned in it. When I will not place it, I'll show it. Will not on a place. So I will like, will not I rely upon letter dated 5th May 2025. My learned friend's consideration is the appeal court, while relying upon the document of 5th May 2025, there were two documents, document A and document B. It has considered document B and not document A. That is all. Millard, if that is all, whether it's Millard, first point is whether Millard, it can be a ground of review. Lordship has to test that. On the face of the document itself, on the face of the Millard, the impugned Millard, order and review itself, I don't see impugned, the order reviewed against Millard. That speaks for itself. And what was his case in the writ petition? What was his case in the appeal court?
Those are on merits, Millard. Those are on merits.
Not on merits. Millard, it's a question how he has projected his case. Because Lordship for review, it's not a court of appeal.
No.
It's very, very limited.
Yes.
And the scope is very circumscribed. Whether Millard non-consideration of a document is a ground for review.
That is why. That is.
That may be a ground for appeal, but can it be a ground for reopening by way of a review? That is all Lordship has to. If his case is a best argument case, as we say, if it's a best argument case, because reference to the document, I'm grateful that he gave me the SLP. I'm grateful to him, If your Lordship takes the SLP papers, what was relied upon and how the court proceed will straight away come. Lordship will decide it. No difficulty.
Here's where I join issues. It is not non-consideration of a document. Had it been limited, my lord, to non-consideration of a document, maybe what Mr. Ghosh says might have some matter of relevance, my lord. But here is the case, my lord. It's a non-consideration of a document and reliance upon another document which has got no material bearing. And my lord, I say, had the court taken into account the document which was required to be relied upon, this order would not have been passed. So, my lord, the error apparent is, my lord.
Mr. Bordon, please show me your grounds of SLP.
Yes, my lord. Grounds of SLP. Kindly see, my lord. Those would come, my lord, at page 103, my lord, of
this paper book. 103.
Lord, that is one issue, my lord. That is an issue on SLP. Today, my lord knows even if my SLP is dismissed at the stage of admission, my lord, I have a right of review.
Let me see.
So, my lord, I should not be circumscribed, my lord, within the grounds, my lord, espoused in the SLP.
SLP ground page 30.
কোথায় 30?
তিরিশ নম্বর পাতায় SLP ground কি বলছো তুমি তো দিয়েছো ground
30.
Grounds, 103.
Yes, grounds of SLP.
Page 30. Page 30.
Page 30. What is page 103?
Just kindly gives me a moment. Kindly gives me a moment.
Ground in High Court. Lordship asked for SLP ground.
SLP grounds.
30. Page 30. No,
ঠিক আছে, তুমি বলছো I don't distrust you, never. My lord, I stand corrected. My lord, the grounds are at page 30. হ্যাঁ, নিশ্চয়ই।
Yes. What is the date of the letters? 20th
of March.
20th of March.
13th.
Any reference to that in the grounds of special leave petition?
No.
Yes.
So, my lord, this was the SLP stage, my lord. We are before the review court. So, the grounds, my lord, I cannot be circumscribed, my lord, within the grounds put forth in SLP. Here, my ground, my lord, if my lord takes my grounds in the review, my lord.
That is at page 103.
No. That was it before the Court of Appeal.
Oh, yes, before the Court of Appeal.
Of review, my lord, would appear for the memorandum of review, my lord.
Oh.
So here, my lord, grounds 4, 5, and 10 are very specific, my lord. Other grounds would also, my lord, tantamount there too, but 4, 5, and 10 are specific. So far the documents are concerned.
4, 5, and 10.
4, 5, and 10. Where, my lord, I say that the document dated 20th of March.
Yes.
But permits me to place both the documents for one month. This will dispel the confusion. Page 63 of the SLP paper. Kindly seize, my lord. Reference number such and such, dated 23, 2013, 21, 2013. Then seize, my lord. FDs in its meeting held on 23, 2013 approved the proposal for base rate of HSD on bulk consumer price with effect from 18/1/2013. So, my lord, here the FDs have already approved the proposal, my lord. The proposal stands approved. It's not hedged with any other future conditions, my lord. So we say, relying on this document, my lord, that, my lord, the
FDs are the final decision.
Functional directors.
My question to you, are FDs the ultimate decision taking authority?
Yes. Insofar as my list is concerned, this is it.
It does not require further approval, ratification, anything by any higher authority.
So, my lord, now kindly seize. Now, this is, my lord, an approval of the proposal. So the proposal is approved, my lord. Nothing further remains to be done. Now, my lord, where the confusion starts, it is now page 64, my lord. Kindly seize. ECL Board of Directors had approved the modification to be incorporated in the GTC in the bid document in the meeting 29/2/59 held on 16/2/2013.
It should be 16/2.
It should be 16/2. 16/2, my lord. Item number 259.04H, copy of letter of company secretary such and such, enclosed, self-explanatory, my lord. So, my lord, now kindly seize, my lord, the next page, page 65. 9/4/2013, my lord, kindly even marks this. Seize, my lord, in continuation of a letter dated 23/2013. Now, my lord, kindly seize. My lord, at page 66, my lord, the issuing authority, General Manager CMC. My lord, page 66, the issuing authority is General Manager CMC.
Page 63.
The issuing authority of the letter, my lord, dated 9th of April 2013 is the General Manager CMC. Now, my lord, kindly now seize, in continuation of our earlier letter dated 23/2013. Now, my lord, this letter, earlier dated, letter dated 23/2013 would be the letter at page 64. Now, kindly seize the letter at page 64 issued the issuing authority, General Manager. So, my lord, this 9th of April letter is being issued, my lord, consequent and pursuant to, my lord, the earlier letter of 23/13 at page 64. Now, my lord, in continuation of the earlier letter dated such and such in respect of modification to be incorporation GTC, that will be general terms of conduct, in the bid document approved by ECL Board of Directors in its 259 meeting held in item number such and such, the diesel escalation formula shall be as follows against earlier approved formula. Now, my lord, again, seize, my lord, the letter at page 67. Kindly marks the date. 14/6/2013. Again, my lord, in continuation of an earlier letter dated such and such, this is to intimate you the proposal was approved by the Board of Directors in its 22nd meeting held on such and such for incorporating the words contracts between such and such. Now, my lord, the reason I place this, my lord, is for for a purpose, my lord. Now, my lord, kindly cease the judgment under review. Why I say, my lord, the document that is at page 64 has been relied upon and not 63 would be apparent, my lord, from the operative portion of the judgment, my lord, which takes into consideration, my lord, the letters dated 14/6 and 9/4. Now, my lord, kindly see page 23 of the judgment under review. You've seen it, my lord? Page 23 of the judgment under review, my lord.
Mr. Bordon, what is the document at page 69?
69. But this is on 10th of December 2013.
What does it speak of?
This was the bone of contention, my lord. We said that this letter could not have been issued in view of the letter dated 20th of March. That was what my writ petition was all about.
Mr. Bordon, which authority is higher in rank? FDs or general manager?
No, my lord, kindly, my lord. These are separate issues altogether, my lord. Kindly cease. This is to.
I'm asking you, who is higher in rank?
My lord, the hierarchy would depend on the nature of duties that they are performing or the functions they're performing. Insofar as our issue is concerned, my lord, the functional directors are the persons, my lord, who were entitled to take the decision, and they have taken. It was only
so according to you, general manager did not have the authority to set aside that.
Yes.
Show me your grounds in the writ petition.
I'll show me. Kindly see.
Show me your grounds in the writ petition.
The writ petition starts at page 41.
It is here. Writ petition is here. Thank you. So you have incorporated. Yes. No, otherwise we have to go through. That creates a difficulty. Yes. No, is it 41? No.
Not the SLP.
Not the SLP.
Why not?
No, the grounds in the writ petition. I think page 87. No.
Page 84, Lordship.
Yes, page 84. Yes.
Mullah, seize the grounds, Mullah.
Yes.
That starts, Mullah, at 103.
Where is that ground that that is beyond their power?
Kindly cease, Mullah, kindly cease.
Because you are challenging the authority of general manager to suspend.
No, Mullah, kindly cease now. If in that event, what's falling from my lord, kindly cease my prayers in the writ petition, Mullah. Kindly cease the prayers in it.
Yes. Mr. Bordon, your prayer will be for setting aside of that.
Yes,
no
Mullah.
issues on that.
Why? The reason behind it, Mullah.
What is the reason? There are two things.
Kindly cease, Mullah.
Mr. Bordon, from those documents, according to you, functional directors took a final decision.
Yes.
At that stage. Now, the general manager suspended that.
No, Mullah, this not.
General manager suspended that.
No, Mullah, kindly cease. This not in that fashion, Mullah. Kindly cease. Once they have granted me the benefit, then what they do is they go back on it.
No. Yes. I follow your argument. They could not have suspended.
Yes.
That's a different thing altogether. My query to you is not that. So, functional directors, according to you, page 63, a final decision with regard to your entitlement.
Yes.
Some entitlement was finalized.
Yes.
Attained finality. Now, by an authority X,
yes,
which according to you is the ultimate decision-taking authority with regard to that.
Yes.
Now,
that's point number one.
yes,
See,
now,
point number two is this letter of 20th of March does not say that this approval is hedged with certain conditions.
no. I follow your.
That's the second issue, Mulad.
Yes, yes.
Promissory estoppel.
Yes. So that is why. So the first point takes cover of both because this attains finality so far as your entitlement is concerned. Now, page 69 is the document which infringed your right, finalized by page 63.
185 which is the part of the FMA 180.
Yes. Now, Mulad, kindly cease. This is to inform you that the functional directors in his meeting held on 18/11/13 after detailed deliberation approved for suspension. So, Mulad, the functional directors approved suspension. It is not with the GM has taken suspension. It's the functional directors after the letter of 20th of March,
Taking back the
wherein, Mulad, it had granted me. Let's see. Meeting held on 18/11 after detailed deliberation approved for suspension. So, Mulad, this benefit was accorded to me by the functional directors and, Mulad, retracted by the functional directors itself.
Show me your prayer in the writ petition. Which are you challenging?
Well, the prayers would be at 108.
Yes. What have you prayed for setting aside?
Kindly cease, Mulad.
Yes. Which decision?
Directing the respondent subordinates, men agents on each of them to forthwith grant, disburse additional payments. Then, Mulad, mandamus directing the respondents such and such. Then, Mulad, kindly cease. This 9th October 2009. Then, Mulad, then cease, Mulad.
18th of November 2013 is under challenge.
Yes.
Where is that?
Mulad, what happened, Mulad? In 18th of November, Mulad, they have sought to retract the benefits.
Yes. Where is that challenge?
Mulad, the retraction of benefits is under challenge, Mulad. Kindly cease.
Maybe you have challenged that decision of 18th of November.
Mulad, kindly cease, Mulad. What was challenged? Mulad, the challenge was the retraction of the benefits.
The decision taken on 18th of November 2013, according to you.
Yes.
Show me that you have paid for setting aside of.
Kindly cease, Mulad. Kindly cease. Ground, Mulad, the prayer C.
Prayer C.
C. Mulad, what they have done is, after Mulad passing this order, they have, Mulad, withheld.
Show me that 18th of November you have paid for setting aside.
Not be successful. I cannot make any previous deduction from his bills. That is the order. The order is future benefits he will not get, but deduction I cannot make. Lordship has striken a balance that whatever he has got, but future he will not get. That is.
Show me that you have challenged Mr. Bordon.
I'll just page
284 or 240, 240.
But he is successful.
Two
Admitted alternatively. If you take decisions of the
Mulad, kindly, Mulad, has seen my prayers, Mulad, at C onwards.
Yes.
What I have prayed for in C, Mulad. I have said that the
I will come to that. 18th of November 2013 is not under challenge.
No, it's not under challenge. What I have challenged is, Mulad, the withdrawal of the benefits. The withdrawal of the benefits, Mulad, which was granted to me by the letter of 20th of March and retracted, Mulad, Mulad, on 18th of November.
That is not under challenge, Mr. Bordon. Show me that you have challenged. Mr. Bordon, there are two things. One is, yes, retraction of certain benefits.
Yes.
But that is pursuant to a decision not under challenge.
No, Mulad, kindly seize this. Kindly seize this. Kindly seize this one. I'll just take a moment of my lord.
On 22nd, 3:30 আছে তো আজ বলে যাও or lordship I can be at 4 o'clock, no difficulty. We have less.
So resolution of the bar we cannot. This is what we've been taught.
I have no difficulty. Whatever lordship feels.
It's a difficulty because
I am here, but I have no difficulty. I'll be here. No difficulty if he wants to argue.
how much time Mr. Bordoni will
It
take?
will take some time, Mulad, because
time.
this question now, which is fallen now, Mulad, we say, na, what I say is, Mulad, that is not required to be, Mulad.
Lordship looks at Mr. Hirok Mitra's argument.
Fine.
That's all.
I was placing that.
Hirok Mitra's argument.
Absolutely. Mr. Mitra's argument, the findings of the court of first instance, everything I'll be placing. Everything I'll be placing. Mulad, I have challenged the retraction of my benefits. The withdrawal of my benefits have been challenged. Which
Mr. Bordon, that was the grounds available. Why did you withdraw that special leave petition? It was larger scope was there.
Mulad, here
Because this is the easiest way. You could say
To
yes,
push an
look,
XLP.
this is
Look,
yes,
this is the
this is
document.
the document on consideration. So
I was
by
not
one
there.
stro-
I was not there, Mulad, so I am not the right person to comment, Mulad. I was not
So
there.
that is the best ground, Mr. Bordon.
Then otherwise,
Mr. Bordon is just a friend of mine. It's
Mr.
the economic policy of the government.
Mr.
Can it
Bordon,
be challenged by a
since
written file like this? It
since
can't
you are taking
economic
much of
policy
time
can't be challenged.
to make out a point, so it's a re-argument.
Mulad, I
On
say,
that ground itself,
Mulad, I
it
say,
has to be
I say,
dismissed.
Mulad, I'll,
And
in the
it
lighter
will be
side, Mulad, on the lighter side, once you look at
2025.
the petition, I believe that I have made out a case for review.
Not at all. Not at all.
No.
I'll show the judgment.
Since
It
you are
was only
saying that
section
this,
5.
since you are saying with those two documents, relevance.
Yes.
Relevance has to be considered only for the purpose, how it is relevant for that. And now,
Within the ambit of Miller Order 47.
you are taking so much argument, long drawn argument.
No.
There are decisions which say
Decisions.
review no.
Today, Mulad, today,
Review if a long drawn hearing is necessary,
Mulad,
is
today
required.
what I am on, Mulad,
Review.
today what I am on is for me to succeed in the review. I'll just have to show that the document of 20th, which was relied upon, was not the document which was required to be relied upon. Mulad, if I can satisfy my lords on that point, Mulad, I believe I have made out a ground for review. Once I've made out a ground for review, Mulad, then I go to the main merits.
That is, Mr. Bordon, non-consideration of a relevant document and consideration of a relevant piece of evidence.
Irrelevant.
Yes, non-consideration of a relevant piece of evidence and consideration
Of an
irrelevant evidence.
That's a
Both are
No, that is also not a review.
grounds of appeal.
Those
So
are-
both are grounds of appeal. So
Mulad, I won't stop short of that. What I say, Mulad, had these operated in different fields, Mulad, those were grounds of appeal. But here what happens is, Mulad, the same document, the letter dated
2024 SCC online 3112 16.7 16.1 দুটো কপি আছে একটা কপি দেবে দুটো জজ স্যারকে 2024 SCC online 3112 মিলাদ 16.1 16.2 16.7
online SC3
I give to my
because Mulad, what I will also be arguing, Mulad,
that if it's a long drawn process reasoning not a review at all. This is exactly what it does.
proposition.
I will also be arguing, Mulad,
It follows the earlier view.
the law of review as it, Mulad, applies to writ petitions.
Kindly have a
It
look
is
at
not hedged, Mulad, in similar
wrong order, non-consideration of documents,
no,
considering wrong documents,
all
not a ground of review, Miller.
But when they operate in different
I am not also, Miller, shying away from merits, Miller. To me,
when
Miller,
when they
2025,
operate at different fields, Mulad, these are settled proposition of law.
kindly
Mulad,
look at
the
it.
issue is, Mulad,
I argue on merits also. No difficulty. It's always nice to hear my learned friend on the other side. I'll also argue on merits.
Then the easiest way is to set aside this, to again you decide the appeal. Everything goes.
This is appeal.
Yes, you are going of the argument.
Besides the appeal.
Not
Again,
before us.
reasoning.
Again,
Yes, before Willard, again Willard. Lordship, why?
Where?
but Review, after reviewing, we will be releasing before the regular range.
I cannot forum shop, my lord. Anywhere, my lord sends me, I'll go.
Not a case of review. This was Mr. Mitra's argument all through.
No, certainly not. My lord, I say, my lord, if the documents operate in different fields, my lord, then those are grounds for appeal. But not when, my lord, a document of a particular date is, my lord, not looked into, and another document of similar date has been erroneously looked into. That's, my lord, I said error apparent on the face of the record.
Kindly, look at the balance.
That part, review jurisdiction, my lord, while adjudicating application under 226, my lord, is far, far wider than the review jurisdiction as contemplated under Order 47.
This is 226 review case.
Show that.
Review case, 226.
I'll show that, my lord. There are division bench judgments of our court, my lord, Supreme Court, which says, my lord, the plenary jurisdiction of the High Court, when it comes to, my lord, deciding points of review, is far, far wider than that of a Section 47, my lord.
Mr. Bordon, this is the reason why that decision was passed by the Honorable Supreme Court, review by change of
advocate. Yes, that is I have you can't help that. Then will not be allowed dismissal. Should be dismissal. Kindly.
And this type of review, it has to be
a change of counsel, not
filed immediately thereafter. So before moving special leave petition, you could have filed that.
Yes, correct.
Because now the bench has also changed. Mr. Bordon, bench has also changed.
I appreciate.
Councils changed.
I appreciate.
So what remains? It's a
This is Tamil Nadu Electricity Board bill.
Point is, my lord,
Tamil Nadu Electricity Board.
No option. My lord knows. Mr. Moitru was appearing. My lord knows the circumstances in which under which, my lord, we have to change the council.
Kindly look at Tamil Nadu Electricity Board. It's hearing at by Leonard Prince.
Immediately thereafter, you
should have filed.
Oh, why SLP?
In SLP.
According to you, it's an error apparent. Why after SLP? Why not prior to that?
May I pose the point myself? But is
why not prior to that? If it is so apparent, Mr. Bordon, it went to you. You advised your client to move. May not be you in particular. I'm not saying, but your client's counsel. So he or she advised to move before this. So now you are saying no, it's an error apparent. So if it's an error apparent, those line of decisions are their review has to be because what arguments were made. Now you will be making a different argument.
I will show it from the arguments recorded by the court.
Maybe those documents may have been in the records, may not have been placed.
And
may not have been placed. Who knows?
I will show from the order itself.
That is why, Mr. Bordon, it says the Supreme Court has said when it is fresh in the minds of the
Tamil Nadu.
Yes, same bench.
No, you had the same bench. You did not.
Before the same bench, if you go after 5 years.
Naturally, they are not there.
No, even if they are there, let us not take 5 years. Let us take 3 years.
2 years.
2 years. After a long time. So that is why Supreme Court made that observation when it is still fresh in the minds of the judge.
It's a plenary jurisdiction Lordship is exercising. Millard equities and Millard the balance of convenience.
Yes.
Millard he is partial successful. Whatever is recovered, whatever he has got, I can't recover, but he will not get it in the future. Is it a ground for you?
That is, yes, that's the ground.
That's not a ground for because you already prayer C is allowed in your favor by the appeal court. I can't go for a